Lordship, CD has not received. Interim is there, Lordship. Well,
3 weeks. Then after 3 weeks,
well,
it is
in
shall con- Item
Obliged,
number
Lord.
43.
Maybe I think maybe I could do it.
Out of
item
22.
We are on,
CD is not available.
You are on interim. After 3 weeks, same. Same time.
actually, 41. Electric.
You want to? Which item?
Not
You want listing tomorrow? Okay.
make it up. I did mention item number. This matter is lost. The target check and take it come after the check.
After vacation.
Charge file, mal.
Charge sheet has
Yes,
32.
subsequent take up after check. It's for
no if charge sheet has
How
been
is the
filed,
charge?
so it has become. We will pass order when it is called.
depend with the one.
Samo kori.
Yes, depend.
Depend with
Depend with the
We will pass orders when it is called.
mal.
May I approach? I am paying for listing my lord and for 38 PL application tomorrow.
What is the offense?
420.
Their lordship the for regular bill and one two more for bill. Item number 44 minutes, probably may not be 18 minutes there. I mean, in 10 minutes.
CD not received, mal. From
What you are on interim.
Yes.
3 weeks.
May please your lordship, I beg to mention item number 26. This matter may be taken after vacation lordship.
26.
26 lordship.
CD not available.
Lordship. Interim may be continued. Interim is
3 weeks.
May I please? Lordship, I am praying for listing of a criminal petition. Lordship. It may come up for hearing, Lordship, after the vacation. Lordship. Any after vacation, either on 8 or 11, because it pertains to maintenance. Lordship. I am for the wife, Lordship. And there is a
Which
stay order
column-
is operating.
Which column you want? Hearing column.
Yes. Lordship. Let it be after vacation.
You
Lordship.
pray before registry.
No,
or
Lordship, if,
After vacation.
after vacation, Lordship, any date, Lordship, 8
No
or
date.
11.
No.
8
No date. After vacation.
after
Second week.
vacation. May it please your lord. Lordship, I beg to mention item number 23, Lordship. I am on interim date, Lordship. Probably case study is not here. May I pray for
23 of- after
Mukal
two,
Market. Season in time.
after 2 weeks.
Highly obliged.
interim may continue. May I please, Lord. I beg to mention item number 37, Lordship. Pass over for
CD received.
CD case diary is there.
Hospital.
Third, Mr.
the Muslim Lord.
M. Sen, counsel for right for adjournment person. There is a case diary which is available at meditation.
But the interim is
No,
interim order is here.
then we will take it up
Yes,
when
mal.
when the matter is called.
Unnecessary. It can be disposed of.
We will dispose it of. Why are you praying for? I'm not-
I have some difficulty, Lordship.
Then we'll take it up tomorrow
Question.
because CD is there. Fix it.
Soon. Wait, please, Lord. Day after tomorrow.
7 years, less than 7.
Yes, Lord. DPO.
may I please. I beg
Item number 8.
to kindly add to
Mr. What is your name?
Mir Masuda.
M.
M.
M. Ahmed. On what ground you are praying for adjournment? Yes,
On what?
Mr. On what ground?
My senior out of
On the personal difficulty of the senior affecting officer. Considering ground nature, the prayer is allowed. Let this matter stay after
but if
vacation.
possible,
No,
kindly fix.
no, do it. First week of after vacation.
May senior I beg to mention listing criminal petition Friday. Obliged.
When do you want?
On 20. Maybe. Both parties are applicant. Petition work article 36 date. All for
What, Mr.
Yeah.
Yeah, yeah. Purpose. What purpose?
on my lot 5-1.
5-1 for
Maybe 439 April. Petition was arrested on 6/8/22. Second payload 1 year 4 months 46. The fair dot the fair will find dot the initially dot they were arrested the present case.
43D is applicable. Can copy of the case report. Heard, Mr.
I
I use also heard. Report. Considering nature of offense, perusal of the can copy of case report section case number 10 that along with case diary of forfeiture 7 and call for the 60 to take steps for which let this matter be discussed
immediately up
again
On 19-1.
on 19.
public.
Based on today 34 is accusation under section 21 D law
21.
21 D.
This is a pending investigation.
Yes.
Yes, sir. Heard Mr. M.I. said that after what also heard he brought up considering the nature of it made fire against the
On 10-1.
Public. I am the driver and I carry the vehicle registration number 01 and
When were you arrested?
22-11.
I was arrested on 22 November
How many days?
23.
Is there would be required?
Immediate on
Immediately on Rio.
3-1.
20.
No, your prayer was rejected by the trial court
Yes.
after perusal of case.
I have a
Immediately on the reopening.
Yes, on 3-1. It's the same matter for owner of the Bitcoin. Let us Bitcoin say Bitcoin. Bitcoin staff
Yeah, but more. Will it be possible?
right now I have no info whether city comes.
Okay, let us how Mr. D. M. Khan, Senate Council for also heard report of the petition. The application of the 439 Court of Appeal has been filed by petitioner Mohammed Rafiq Islam has been detained behind bar since 22/11/2003 connection with Sonapur case in Seven Council for the petitioner has submitted the driver of vehicle. It was seized. He also submitted that in connection with another bail application filed by co-accused, one of the case diary of Sonapur TSA was called for by the coordinate medical report, and he submits that CD may arrive available of the Senate additional public prosecutor shall verify whether CD is available here on that case which is again 22nd for case. If it is available, we take the
Yeah.
otherwise we'll take the
कितना मेटा में अलर्ट अटैच is but
11th April.
Yes.
What is the offense?
Offense under 22 of the
The charge sheet is
Started submit.
statute.
can copy. How Mr. M. Toyota as offense charge offense. This is a charge sheet. What is the stage?
Matter fit for evidence.
Charges are framed
Since the 13 occasion, but no,
as the offense alleged offense under which charges were framed in the is under section 26 Exhibit Act. And Veruda of case record of NDPS case number 47/20, hence call for the scanned copy of the case record of NDPS case 47 along with scanned copy of case that Auraghat case 70 that let this matter that again 19th of
For 39 application lot. And case proceed, the complainant is NI case against the petitioner. And
since when you are behind the bar?
I'm talking I have been custody since 8/12, page number 22 dot. So the extent of NP I have tested. Now I have he issued a check lottery, one more check lottery for lottery for 2 lakh, 2,50,000. But in the meantime lottery when he paid rupees 50,000 to the complainant, and we find page number 12 para 7 lot. In the plate is
Why you fail to appear before the trial?
the 4% take the out of station for his work purpose, and time he is doing vegetable business also. So only one chance may be given or take both case very immediate to it. Only one chance may be
Where is the order?
Okay.
Where is the order?
Order is on page number 22. Connector.
Earlier you were allowed to go on bail.
And subsequently 5 numbers of dead lordship has noted. Admitted. NIA case file on the strength of NBWA.
No, after this, you were happy, you were arrested. You have not moved bail application.
But-
What has happened? That
I-
has to be, that is to be, you take instruction.
Court had planned not.
No, your,
Tomorrow is lordship and the production date.
but you have to present correct facts before the court. My query is, have you moved?
Perhaps not moved.
No, perhaps. You have to, you take instruction.
After some time, I take
At,
it.
at 2, we will take it.
Lot. Yes, my prayer is there, my lord. Page 20 was issued against according to the police personal executive and arrested and prayed for granting of bail to the accused person.
At 2, we will appear. Yes,
May I please, Lordship? Lordship, recent bail application under 439. FIR is in page number 13. I did FIR.
what is the allegation?
Offense under 380 and 429 of AP.
What was the theft? What was stolen?
Plus one
Goat.
other complaints and the accused were neighbor. It is from personal quarrel tip side.
Whereas from the FIR, my lord, they admitted and thereafter, my lord, agreed to pay amount of 5,000.
That money has not,
Yes,
But,
that money has been paid, but they told that
but otherwise custodial detention is
Yes.
not heard. Mr. M. Hendy, and counsel for the city, also heard for her this application 494 has been filed by M. Gautam Sethi has been, how many days you are behind the bar?
12
12 days. Who has been arrested, detained behind the bar since 9/12/2023 in bracket, since last 12 connection. Gopur PS case number 244/2016. The list of execution in this case that there is a this case that on 8/12/2023 what Jumani Rajpur had lost the FIR for the officer in charge Gopur said the petitioner had come up on 26/10/2023 stolen one goat belonging to the first important and sold it in the nearby village. It is also alleged in the affair that petitioner had confessed it in front of parents and agreed to repay value of stolen goat, that is 5,000. However, the, however, he has not repaid back state state 5,000. Council for 42 submit regarding the allegation.
I have not involved in the offense. Even I have not agreed to pay the money. But due to their the complainant is a very poor document. That's why we are need to pay. Okay, we have lost our cost, so we'll pay that.
The story is not convincing. But counsel submit that petitioner has agreed to pay the amount at FIR.
We have already paid the.
However, he is not called the compensation. Considering the value of the stolen property as well as considering the fact that petitioner has already been detained behind the bar last 12 days. Further custodial detention of since last 11 days. Further custodial detention does not appear to be necessary for fair completion of trial. For fair completion, so could be escaped to 40%. The petitioner therefore allowed to go bail of subject that SPAM court. It has cooperate with the type of better.
F439 FIR is lost by one owner of a vehicle against the driver for not delivering 500 bags of cement to Nirjodi within the estimated period of time. Thereafter, the truck was recovered along with 121 bags of cement and the driver was arrested. Thereafter, on the basis of the statements of the driver, the petitioner, who is the owner of a small hardware shop, was arrested for without serving any section 41 and notice to him. And moreover, Lordship 400 section 381 is also not affected in case of the petitioner. The petitioner is not owner of a hardware shop. And the quantum of the LS goods also can be quantified. Majority of the goods have been recovered. Cement bags already 18 days behind the bar.
He is the purchaser of those, my lord,
Stolen property.
cement bags. And my lord, network is continuing only because of the existence of this type of product.
So I'm a small hardware owner.
Is there
Is there any sort of
how many days?
8 days already. And quantum can be quantum of the LS goods can also be quantified. And already 239 bags, already more than 50 bags have already been recovered.
239
Lordship, already 261 bags already recovered.
and got how many were stolen?
Lordship 500 bags. He has lost the FIR on of 500 bags.
On reopening day. Yes, sir.
Yes.
Mr. P. Bordolo, counsel for also heard P. Bordolo. Considering the nature of the perusal of cases that next call for
3-1.
63 for
Like
Praise the Lord. We have filed this petition, my lord, for posting of FIR as well as, my lord, posting of criminal case, my lord, initiated on the basis of FIR. FIR, my lord, case 16,
judge sheet has been laid.
started late.
What is the ground?
Ground, my lord, if you lordship, my lord, consider the entire affair, even then, my lord, it does not, my lord, disclose any offense, my lord, under section 420 or 40. Purely, my lord, civil dispute. The petitioner, my lord, is a contractor, my lord. He, my lord, after submission of tender, he got a forfeit. And the respondent, my lord, the
Where is
informant,
the FIR?
page 16, my lord. I read, my lord. May I read? With due respect, I want to inform you that the contract for building women's cell in Borpeta police station has been allotted to Mr. Biplab Das, the petitioner, my lord. Thereafter, the same work has been started by my father and uncle in the name of Lingajoti Das, is the informant. By filing necessary legal contract papers before Honorable Borpeta Session Court, the work has been completed and handed over to concerned authorities in the year 2009. But unfortunately, Mr. Biplab Das only paid us to total 21 lakhs in 3 installments, and the last one a year ago. After that, Biplab Das started ignoring us in every possible way. We tried to call, tell him, even visited his house several times, but we could not find presence. By seeing the ignorance of Biplab Das, we had no other option but to borrow rupees 8 lakhs from various stores and other people to complete the work. It has been 1 year. The work has been completed. Now the people whom we borrowed money started coming to our house to get their money back. And we are not in condition to return the money as Mr. Biplab Das betrayed us a very pro-face, and I wondered they will choose to dark path. Therefore, with folded hands, I request you
Sir, catch it
now,
during investigation, some evidence have been given.
now, my lord, in the Sarkit law, kindly see, the police said, my lord, I said
Where?
that page 30 in the vernacular. I have translated it also, my lord.
What I said,
Page 30, my lord. Page 29. তদন্ত আলোর ঘটনাস্থল পরিদর্শন করে ঘটনাস্থলীর তুলমূল নকশা অঙ্কন করা হয়। পদকীয়া বিপ্লব সহিত বঙাইগাঁৱৰ পৰা কুচৰিয়াই বৰপেটা উমেন চেল বিল্ডিঙৰ কাম সাব কন্ট্ৰেক্ট লৈ কাম কৰাৰ বাবদ 1.5 লাখ টকা পোৱাৰ সাক্ষী পোৱা যায়। 1.5 লাখ টকা পোৱাৰ দিছ ইজ মানে পিউৰলি মানে চিভিল ট্ৰানজেকশ্যন মানে।
no, you read the second line, page number 30. That sufficient evidence collected.
What will be, my lord, sufficient, my lord? From
That
the
we have-
FIR, my lord.
That we have,
FIR itself, my lord, says, my lord, there is no inducement, no, my lord, dishonest misappropriation, there is no enticement, there is no, my lord, cheating, my lord.
This
Now-
now, scan copy may be called for. Thereafter,
Now,
my lord, if
I
nothing found
want
on
to
the-
rely on judgment, my lord. Subsequently consider. Practically similar case, my lord. You can agree, my lord. Now, this is the trend of to, my lord, file criminal case. Paragraph 27, my lord. 26. I see paragraph 22. 406, 405. The condition of the court is paragraph 20.
no, okay.
prima facie
Clear?
seems to be a civil dispute,
Clear?
but circuit submitted to LKR may come thereafter, my lord, if
Because
nothing found.
So, why, my lord, my lord, clearly it is a process of court, my lord, and law.
no, let us,
So, my
let us
lord,
peruse the
so, my lord, the further posting may kindly read. Your lordship clearly covered case by the Honorable Supreme Court.
not without going
We thought that maybe fixed thereafter, my lord, the entire matter
out
can be
with the
disposed.
RL. You have annexed the 161 statement
No, it was not fine.
that we have.
Yes.
If there is
It
no
was
need,
not fine.
God,
One will come, my lord, the FIR, my lord. Full foundation is the FIR.
this application for it, the court of right of the praying for watching criminal of PRC 554 that arise for it where pictures of FIR was not equal one or better other for the paid the payback amount. How much is the
No.
outstanding?
There is no standing in, there is no claim also, my lord. Entire work was for 36 lakhs. As per official, my lord, document, he completed 60%. 21 lakhs he got, my lord. I have paid 21 lakhs. So he got, my lord, his entire amount. But this is the official document, my lord. Page 26, my lord.
No, what they take it
Deletion that, my lord, he took subcontract, my lord, from me. And after completion, I did not pay him money.
shows that it but no of it made up of content of FIR. He also submits that even from the result of that it has been paid against the appears that only evidence collected is that had to, he had an outstanding contact of Right.
One or one, like,
1 lakh,
ek 10 lakh. This is the length.
1 to 1 lakh 50 or that something or it submit that the net proceeding has been drawn up by on the basis of the FIR only to FIR laws by the court harass the city. Though there may be a civil dispute between the petitioner as well as first court. But which is the 11th paragraph judgment cited by
Paragraph 22, my lord, regarding 406 and 27 regarding 14.
Senate counsel for this petition has also submitted that the perusal of the FIR as well as charge sheet does not disclose any offense or the other hand, that 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 the that of it get 550 that case area for better as one for that that take that was within 3 days from date of of how it was treated as apparent either by that process any period that date would but we are by 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 till the clock
Chief Whip.
of the court.
Look, 438 application, my lord. Section raised under my lord, 379 and 411. FIR lordship will find that page 12. Allegation is that some electrical my lord, conductor was stolen. Unknown person. Subsequently, 2 persons were arrested. Petitioner is not named in the FIR, my lord. Where is the FIR, my lord?
No, then why are you objecting?
My lord, in forwarding report, I have annexed, my lord. Lordship will find that page 16. One line is there, my lord. During investigation, lordship. Lordship, find, my lord, second para.
Yes.
During investigation, last line, my lord. During investigation, the accused person confessed their involvement into the case and stated that they stored the items in Abdul Salam. Abdul Salam is the present petitioner and carried to dam for illegally selling. So, my lord, that is why police is visiting the house of the present petitioner. My lord, arrested accused person and present petitioner will belong to the same village. Sometimes, my lord, they used to, my lord, purchase the, my lord, scrap materials from the individuals and they used to sell it in the dump. Sometimes, my lord, they store it in the house of the present petitioner. The present petitioner is a teacher, my lord. So he allowed, being a same villager, my lord, he allowed them to store it their house, in his house. They have
Where
taken
is
their,
the statement that,
my lord.
where is the statement in which page that,
Yes, my lord. I have stated, my lord. Lordship will
no,
find
no. Indeed, where is the forwarding
forwarding
16.
report. Page 16, my lord. Page 16.
16? Where is the mention that voting?
Lordship will find,
Second paragraph.
yes, my lord, brief of the case, thereafter second para. The fourth line. Well, petitioner 379 is not attracted, even if my lord, only 411 may be attracted, even if, but he is not purchaser. He only allowed them to store it. So, my lord, let his statement be recorded, my lord. That is my submission, my lord.
Only difficulty is when some of the accused person were comprehended
Yes,
and
yes.
some of the stolen articles recovered, but some are yet to be recovered.
No. All stolen I can still recover. If it replaced by the one forwarding report.
Last line, my lord, deaths are other accused involved with the case yet to be arrested and examined.
Maybe, my lord.
His release on bail may harm the so finding purpose, as other stolen articles of the case are yet to be recovered.
These forwarding report in respect of my lord Sumail Ali and Jalil Ali. Present petitioner is teacher.
Third, it's the NK question. Application report, report of right, right, Abdul Salam, who is preventing that more list of application on 9/12 one much has lost and fire report officer in charge of reporting in charge of hospital out Thomas there in Jacoba that on 1/12 at night about 500 meters from conductor of 460 very big conductor
My lord, the particular is the people.
on the KV Patana data figure as provided by thereafter who were portrayed
My lord, at page 17, my lord. This Sumal Ali
thereafter
and Mohammed Jalil Ali.
who accused for namely Kumal Ali and Jalil Ali were apprehended by police and the arrested person have confessed that they had stolen the said article and had stored the stolen article in the house of the Learned Council for it and submitted the teacher verification. And though he allowed the other co-accused person stored articles out was without his knowledge. It was without his knowledge that they were stolen. The Council for fear of he allowed the teacher had allowed some persons of his own village store scrap material. Also submitted by the Council for Credit. The other hand, the deputy of the Viruddha of the of
My lord. On 4th of January. In case of granting interim, my lord, on 24th of January.
report for in the meanwhile considering the fact that name of the petitioner has been implicated in the case, the statement of the co-accused, and there is no evidence for the property of petitioner Abdul Salam hereby direct here investigating the Pakistan within a period of 10 days from the date of and cooperate if he does so with stipulated period of in the event of his arrest, connection with Pakistan CPS case court that he shall be allowed to go, but if he requests that the court 24
24.
All right. Wait, Ballot court made the application now that the FIR has been registered under section 334 and 506 matter. Except my lord, 334 or the responsible. And my lord, this case, my lord, I am appearing on behalf of the accused number 2, man. My lord, your lordship, from page number 5, paragraph 8, man, how he is called. Even my lord, the FIR, the woman doesn't know the full name of the accused number 2, my lord, the petitioner, the present petitioner, my lord. My lord, if you lordship comes to page 5, paragraph 8, my lord, may I read, my lord? The accused petitioner begs to state that he is nowhere connected, involved in this case, and he has not even met the informant for just once. He is a cousin of
no,
the
what
accused.
was the allegation?
My lord, allegation is that the informant and the accused number 1 are both are in relationship, were in relationship for last many years. And accused number 2 is the cousin of the accused number 1, man. Cousin brother, man. My lord. When the
Then what was the allegation?
Well,
What is alleged?
alleged, my lord, he demanded money, the accused number 1 demanded money from the informant, my lord. And in this regard, my lord, the informant did cruelty against the informant, against the accused number 1. If your lordship comes to page, my lord, 14, my lord, an affair has been lost by the accused number 1, where the informant was granted bail by this honorable court. Even, my lord, the accused number 2 informed me that the accused number 1 and the informant have started living together again, man.
No, my query to you is what is the allegation?
My lord,
Allegation is of
my lord,
assault. is of-
Earlier, my lord, he lost the case against the present, my lord, informant.
informant, my lord.
Now, in this case, allegation is that only, my lord, he demanded money from the accused person, an amount of rupees 10 lakh to compromise the matter, and the present accused person, along with the present accused Dhiraj Sharma, my lord, physically, my lord, assaulted the,
Whether the present accused also assault, present petitioner also assault.
yes, my lord,
Even, my lord, he
she
never
along,
met, my lord.
she along with one man Dhiraj, she come to kill me and also grievously hurt due to which I have faced. Well, this is the allegation. She along with one man Dhiraj.
My lord, that
Dhiraj
Dhiraj
is the
Sharma is,
present.
my lord, the present petitioner, my lord. Even Dhiraj, my lord, never met the informant.
Main allegation is, my lord, she tortured me by both physically and mentally. When I was in bail, she came to me on in that case, my lord, the present informant is already on bail. She came to me and offered me that she will take rupees 10 lakh to compromise the case and started living with me again.
Main accused, main allegation is against
The
accused number 1, my lord.
Now she demanded an amount of rupees 10 lakh to compromise the matter and also assaulted the my lord victim. That is the allegation.
And even, my lord, the battery incident took place 1/10/2023, and FIR has been lodged, my lord, on 8/12/2023, my lord, after 2 months.
Heard Mr. R. Talwar have opted for petition of the heard this application 438 Court of has filed Viraj Sharma, who is apprehending there in connection with this previous case made on that date that tried to take that right list of execution is the list of execution is that on on 8/12/2023 one Suraj Agarwal had lost that fire court of judge of Interi stating that the first informant was in contact with 150 and was having relationship with her for last 2 years. And it alleged that on 1/10/2023 he said Biblida came to the first informant and pushed the first informant, as a result of which he suffered spinal injury. It is also alleged that he, along with the present petitioner, when the said Timlidas, along with the present petitioner, went to the first informant and demanded with 10 lakh to compromise the case. Facts are okay.
My lord.
That is counsel for submitted for the case before the case filed by court the the accused number 1 named in the FIR and lost and fire in court and Jakarta, and in which case the government had taken it from court. It also alleged, it is also submitted by the counsel for that though the though the incident alleged in the FIR is stated to have occurred on 1/10/2020. However, the FIR against the petitioner was lodged after the day of court 2 months on
8/12.
8/12 without letting cause of it further submitted by the counsel for main allegation made in the FIR is against the accused number 1, namely the and only allegation that he accompanied that the on the other hand, the petition submitted the letter of the for submitted for
मतलब 19-1.
91 output by the fact fire has been lost delayed as the loss after the delay of 2 months without any specific of submitted fact that main allegation fact is coexist with same state the fact presently Siraj thereby directed appear for investigating the this should be a case number 8 of last week in a period of 10 days and cooperate if he does so within stipulated period of time in the event of his arrest it could be a the above named at without more interim bail of 30,000 for debt
My lord, of the record, both Hridas and Firoz Agarwal are defeated, my lord.
let us see
My lord. Deeply obliged.
Page 90, my lord, FIR. Yes, I delivered the portion 90, page 21, my lord. In page 21.
Yes.
Intimation regarding perpetrated fraud in the account of Navajyoti Court. My lord, by the before that, item number 45. That is also wrongly listed for bail hearing, not only for same case. The two petitioners, husband and wife. So 45 should be taken up together.
both of which one
Because this is a same case, same affair, but only petitioner for husband and wife. So I filed two petitions, matter for husband and wife. Fine. Now, my lord, intimation of page 21, intimation regarding perpetrated fraud in the account of Navajyoti Kolita and Sheila Borua Kolita, both residing house number so at PT Chalieri Road, Lakshmi Restaurant, Silpuguri, Guwahati, having loan account in the United Bank of India, Secretariat Dispute Branch. This is, my lord, the law FIR was lost by India, UPI, United Bank of India. ISV Samuel Kumar Datta, Chief Manager, United Bank of India, Secretariat Branch, do have an intimate concern authority that captain borrower have perpetrated fraud with the bank by submission of fake and false document. The borrower are made connivance with each other and made conspiracy to defraud and cheat the bank. Defraud and cheat the bank. The borrower has applied for UPI for housing loan on so
for sanctioned a loan at the time to rupees 28 lakh. 20 lakh was sanctioned. And they have availed. And which are dated as transfer. The loan was obtained by false repetition, fabricate documents, false document. ITP and Form 16 Guatemala transfer. Therefore, Punjab National Bank, Punjab and Sind Bank have intimated this office that the captain borrower has obtained loan from their branch with the same document and securities. Transfer. My lord, this is twofold, my lord. One fold is that I have I have committed fraud by giving fraud document, especially alleged to the bank. My lord, what happened? I have applied for loan. I got that loan, but I have applied not directly with the bank. I have not gone to the bank. I have that time there was a DSA agent, direct sales agent. I have submitted all the documents to direct sales agent, and direct sales agent have processed the entire loan. Not I have visited the bank, not I have visited the bank, not I have any personal interaction with the bank officer. The direct sales agent, whatever document I have submitted, whatever document are given by the direct sales agent, I have signed the document. And what the direct sales agent is doing, I don't know. First thing, this is not our signature. Second, my lord, what happened? That when the loan was sanctioned, I used to repay the loan because if I go to the if my intention is to cheat, I would not have paid us any single amount. Page 5, my lord. After sanctioning of the loan in 2016, page 5, 28 and 2016, I paid amount 55,000 installment. 15/11/2016, I paid 45,000.
You are regularly paying
I'm regularly paying.
or there.
No, I'm paying him, my lord. After regularly paying, due to certain
What
help,
documents were forged? Which
What?
document?
Yes. Now, thing is that, my lord, after regularly paying the loan, due to certain sale conditions, I failed to repay. Accordingly, they filed the original application for recovery account before the debt recovery tribunal in the year 2016, 17. That time they didn't put it as the entire document. It was contested. It was expert order has been passed in the debt recovery tribunal against me because I don't know what case they have had. That time the document, DRT also judge after presiding officer have put in the entire document. They didn't find any fault. Anyway, after 2019, they have lost an affair. After 2 years, first. After that, my lord, when the recovery process starts, I have given undertaking that I will pay the entire loan amount. Accordingly, my lord, I have paid 20, after 28 lakhs, I have paid 20 lakhs. This is what I have arranged all the documents, whatever amount I have paid. Page 53 is the statement account which I have paid, and page 54 if you want to go. Page
Yeah.
50 is
Here the question is whether forgery was there,
yes, forgive parties there.
whether you used forged documents.
The loan, but I'm loan. But if my intention is that I would have not, I would not apply for the loan. I would not keep the bank, but I need to do it. I was paying and I'm paying going to pay. Now thing is that my lord. Now what is the happen? Bank is trying to pressurize. This is pure tactics of the bank to pressurize to get to recover the amount. They filed a criminal case. They filed a case. It's a mere civil dispute, my lord. And if it's not a civil dispute, why they have at the time of filing the application before the original application before the deputy tribunal, they would have raised that amount of period. The question that time that I have given false document. They didn't do it. Judgment was passed. After that, my lord, they have lodged an FIR.
No,
Page 50.
the payslip, identity card. form
Yes, my lord.
15.
Yes. And yes, I'm coming to that, my lord. If you love to go through that, my lord, my para, I stated, my lord. If my para stated, my lord. Para 4, my lord, page 4. I have stated. I just read that para.
But yes,
The petitioner has to submit a not present whatever arranged in
okay,
the prior
your plea is that you took loan with the assistance of one intermediary,
yes.
direct sales.
Yeah, that time,
So you are not aware.
yeah, I can.
My lord,
here, well, from the FIR itself, well, it is well very clear that he initially took loan from the Punjab and
Yes,
Sind
yes.
Bank. And
Yes,
by submitting same document, my lord,
No, no,
he
no, no.
obtained
Yeah,
loan from the Punjab, the present United Bank.
Well,
of
I've
India.
annexed that FIR also with Punjab National Bank. What I have FIR? Punjab and Sind Bank FIR also have annexed, and I've got that absolute bill against it. I've annexed all the order, man. If Punjab is Sind Bank so far, Punjab Sind Bank also lost an FIR.
Against you.
Yes, yes,
Where is that bail order?
yes, yes. Page 65. Page 360, my lord, is a FIR lost by Punjab and Sind Bank. This is to implement the home loan available by Sri Namathiti Kolita have declared fraud by the competent authority of our bank. As per document available, page 60. As per document available with us, some more details are given below. Name of the borrower, loan account. This of the case. Mr. Sahabar and Lawler have applied for housing loan 28 lakhs. And accordingly, at our Rajgarh branch to purchase floor constituting 35 lakhs from Hida Bala Kolita. A deed of agreement for sale of floor was executed, wherein it is mentioned that resident floor meeting so and so is agreed to sell by sale of seller. Subsequently, the branch sanctioned a loan. Though the parties agreed in the above mentioned deed agreement of the sale deed, after obtaining necessary permission from the competent authority, the same was never applied, nor execution of sale taken. Their application is that we have deposited the title deed. Their allegation is not there, that I have given false document. There no mortgage, they have said that no mortgage has been created because I have not deposited any title. How can I deposit? They have given a this loan has been given because already their loan is that the title is already deposited with the Punjab United Bank. How can we deposit the same title deed with the Punjab National Punjab State Bank? Here, this is my lord. Second, but creating of second charge, they have taken that. And my lord, after that, my lord, I have applied for bail. If you also go through that bail order, 67 page,
No, there the allegation,
different.
the allegation was forgery of deed. Of sale deed or
Yes, not sell it. I have not deposited a sell it. Their allegation
there
is
the
that
allegation that you have forged your identity card,
yes,
your
yes,
Payslip,
yes.
and form.
Form 16.
Form 60, my lord.
Go on.
Yes, I have stated that I have
Yes, that
given-
may be called for.
So, my lord, what I have no objection if the case is for. But thing is that ultimately I have paid the entire amount. What the bank will get from that? What the bank will benefit from that? If I'm going to pay and I'm going to finish the loan, after that nothing will happen. Bank will not take any interest at all. They are only aim is to recover the amount. If they recover it, I just take it some things from some other angle matter. So why the bank will run after me? He will return back my sale, the title deed. Once I paid, they will return my title deed. Then nothing happens. They will throw away that loan application in the basket.
The recovery tribunal also may not pass order against the
Yes,
present.
yes.
Case
Uh,
when-
As Kendra, that is something for also her report. With the application of the section 48 code of common by the apprehending it could be a case 365 dash the 4.4 dash 471. It's topic that on 2010 was the chief manager of United Bank of India had lost an fire for the officer charge of that petitioner. Where are the names that the petitioner and who is Neha? that the petitioner,
Item number 45.
the petitioner took
Which
loan,
one is wife?
petitioner loan from the state bank by submitting fabricated report of it alleged that loan was obtained by submitting forged payslip from a identity card and Form 16 of Guwahati Medical College Hospital. It is also alleged in the FIR that petitioner also obtained another loan, obtained loan from Punjab and Sindh Bank by submitting same document. And security. The Learned Counsel for the petitioner has submitted that petitioner had obtained the loan from state bank through intermediary, namely direct sales agent, and he is not aware back at what documents were submitted to the bank by the direct sales agent at the time when loan was signed. Learned Counsel for the petitioner has submitted that though the petitioner was regularly paying stock installment in state loan, however, it defaulted and sitting on a before the ERT card by bank the year of before the ERT, no such plea was taken by the bank that petitioner had deposited loan. Thereafter, after a gap of 2 years, they have made allegation of the court made that nothing was as regards any loan of the state bank filed fire that it granted be paid by ordinary maybe it paid the that by ordinary that what it has the petitioner has no intention to treat the bank as he has been regularly paying installment till he defaulted. And thereafter, after the directions of ERT, he paid 20 lakh out of the outstanding due of this
28 lakh,
20,
38 lakh.
38 lakh. And we paying many
You also pay.
learned. On the other hand, learned teacher the result of the case diary or case diary
Yes, yes, on 25 on
25 months. How it is fact that that allegation regarding forgery made after that for the tweet by the police. In similar nature case, it was granted bail by coordinate bench. The petitioner is hereby directed where specificating the state by that in a period 10 days that cooperate if he does so. In the event of his arrest connected with this case, state secret the appropriate petitioner without go for any bail of 30 months of satisfaction of it following what is the 45?
What was there? Purva police, the same.
What are the allegations?
Five.
Same
Five,
allegation.
same case, same FIR,
Fire is same.
same FIR.
And you also took earlier bail.
I have also took earlier bail. I have annexed that bail.
Yep.
Same thing.
He is the guarantor.
Guarantor come co-applicant.
Case number 1 is the guru.
Co-applicant.
You also took loan.
He applied along with her husband as co-guarantor, as co-applicant, because you have to show the income. No? So if the both the income can club together, you can hire.
Joint.
Co-applicant,
Otherwise, everything
same contract.
25.
Same contract. Separate based on previously take the 50 numbers of what where this by police
50 number.
50 number.
with respect of that matter, those water park e-way bill was generated and produced by the 2% and that e-way bill was in the name of my lord Malik Garment. I am the proprietor of that Malik.
These 50 numbers of pump belongs to you.
No much. Only the e-way bills were generated by lord in the name of my firm and without my knowledge. And as soon as I came to know about the same matter, kindly come to page number 21. I have cancelled it. Page number 21. Using my credential of my firm, those were issued. Articles were in Morigaon, and I am inhabitant of my lord Dibrugarh.
These from where?
From my lord under Lahori Ghat police station.
From whom?
From my lord one Babul Islam and one Yusuf.
My lord, page 19 is the my lord forwarding report.
Yes, my lord. They were arrested, and as per my knowledge, my lord, they have already been
Total my lord 50 numbers of my lord water pumps by using my lord fake e-way bills and my lord
Is the way with
yes, these e-way bills.
how you are involved? Why are you apprehending?
because my lord in the name of my firm. That's
No,
why
but police is not touching.
I that's why
This case they may come my lord, any sort that may be fixed. my lord.
and so far my allegation is and that it documented only regarding e-way bill.
which has already been seized, my lord. Case number 18. Sir. All the 50 numbers of forms, my lord. X invoice and EUA bill number so and so, my lord, has been seized, my lord. That is
No, if it is back with that's not so.
Anyway, but this is the, my lord, tactic, how they, my lord, using those fake UA bills. The name purchaser is, my lord, they name someone as purchaser and destination. Ultimately, those, my lord, purchaser, destination, everything was, my lord, later on found to be fake. And now here in this case also, those by using that UA bill,
But
this,
it
my
is
lord,
not seized
from
his
his,
EWA
but
bill.
how he is involved, because in the forwarding report anywhere his name is not there. So now he has approached before this honor. Probably police has, what are the materials against him for that, my lord?
Let me clear.
Yes.
Or Mr. UK
H.
H.
Ali.
H. Ali, Senate Council for also heard the board of this application for the court has been filed by Abdul Malik apprehending arrest connection Lahori Ghat case number 288 under section 379 411 47 49 4 the case of preparation that that on FIR is at page 16
yes,
that 77 1 feet that caused the fire that Lahori Ghat there is a that on the receipt of secret information lab in search of conducted at Portwood and 15 numbers of water pumps were found Babu Dam which were suspected stolen. The FIR name in the FIR 4 name of 4 accused persons are mentioned, wherein the name of later on during investigation the apprehended but produced the tax invoice as well as eBay bill generated by the Malik Garment of the which and the present proprietor of state that is Council for has submitted that credentials of the firm belonging to the present right state generate fake credit. And after coming of this fact, the petitioner had cancelled the bill on 16th Feb. South Sudan Council for has that though the in no way called the office related to the affair and has not been named in the affair. However, the police searching for favorable or the other hand, but nowadays generate fake dates
And my lord, EUA bill was cancelled after commission of the offence.
and we can therefore that there is a case that proper when
My lord, on 18/1 month,
between
18/1.
even that has not been made by eBay and not the after coming that prediction of generate fake having
11. 11. Sorry, 15.
having by correct fear within a period and cooperate if that stipulated traffic at with the of the paid of at the traffic with that
My lord, matter attention to anomalies of distribution of PTS tax. In this case, my lord, the specific allegations against who they have been released on bail, and nothing is from him. Kindly see this FIR. The specific allegation against the three parties,
at which page
page 18 is the FIR. May I read, my lord? Specific allegation against the Ramayana secretary and the two
how many bags
here, my lord, 18 bags to Samiran Vista. May I read, my lord? With due regard and
Total
with-
140 number.
no, no, my lord.
instead of reading what is the allegation
Allegation, my
That is
lord,
very long affair.
Yes.
longer
my lord.
time. My lord, only I am saying, only I am saying.
You tell me the
This, my on, my lord, on the basis of information, police, my lord, raid upon the secretary's premise, where he police recovered
secretary of
secretary of the Gandhai Brahmantation Cooperative Society. And in his rented godown, police recovered 140 numbers of bags.
140
140. And accordingly, my lord, police and also some documents have been recovered from other two persons, which is who are my lord Angshu Dotto and Nakib Ahmed. And accordingly, these three persons have been arrested. Now, on asking the secretary is saying that I have distributed, he distributed all the rice bags to the agents, to various agents. And on the basis of their statement, my lord, they are saying that then 80 bags distributed to petition, 18 bags, only 1/8, this is in middle. And this is the allegation. And my lord, the police have not recovered anything from me. Anything, not recovered anything from me, my
what
lord.
is your name
My name is Samiran
Vishwas.
Vishwas.
18 bags from the present
18 bags to
accused.
Samiran Vishwas.
And my lord, other accused persons obtained bail of, from after my lord, PA, my lord, all those.
And these three persons have been released on bail, my lord.
And on the bail order, it is saying that all allegations against the Ramanshu protection. That is the secretary, my lord. I am not held along here, my lord. Only to shift the burden, my lord. Secretary mentioned my name, saying that he distributed, my lord, all the bags to the agent. And accordingly, his statement, my lord, the police is.
Now, what has happened to Amanchu?
He is released on bail, my lord. His bail order,
for
my lord.
judicial custody.
Kindly see page number 37. Ramanshu Bhattacharjee, page 37. He has been granted bail, my lord.
And what you have did with it,
I have not, my lord. I am saying, I am denying that. Not
it's false.
this is false, totally false, my lord.
SDI will be required. my lord.
Because 140.
Well, because this FIR is lodged after my lord preliminary inquiry, my lord, during preliminary it is learned that the accused persons are involved
Okay,
in-
but the main accused are
on bail because after judicial custody he is on anticipatory bail. So SDI will be required.
And my lord, 140 bags has been recovered from the Ramanshu Bhattacharjee, not from me, my lord. How can he distribute it to me, my lord? Nothing against me, in fact, my lord, even on the face of the record.
hard.
Page
It's
30.
hard. Clarification. With Right. No, it's not on
Yes, my lord.
Not on the basis of it.
liable.
Yes, my lord, during preliminary inquiry it is learned that the accused persons are involved in unfair and corrupt practices of misappropriating PD rights.
Preliminary inquiry by the court.
Yes,
This accused person, my lord, this Ramanshu,
They are
Anshu and Nakiba.
those PDS rights are meant for my lord 4 persons and they are my lord,
Inter alia
illegally.
stating that ethics of information received from lab sources regarding anomalies which anomalies occurring in the distribution of PDS rights by Gathai
Brahman Sat-
Brahman Sahar Sasha
Cooperative.
Cooperative Society. A search operation was conducted. Entered go down of the said cooperative society located at South and at search during search one 12-wheeler truck bearing registration number NM01K 9740 loaded with 140 worth of rice. Numbers of rice bags were found
We took the court out.
what is 50 bags
This is also recovered from the possession of the Ramanshu Bhattacharjee.
in addition to 140. This is in addition to 140. That
Yes,
another,
addition to 140.
another 50 other,
Another 22 bags, my lord, 50 kg each.
another 22 bags of 50 kg of another bag. That 20 kg the standing front of court. During preliminary inquiry, it was revealed by Chief Number 1, namely Japan, Ramyan Bajaj, that said rice were lifted from market till the shortage for making distribution. And out of said rice, 30 bags were bags were given one to not 40 bags were delivered one to the and similarly, who are these
These are the agents.
separately some other ones of rice were given other agents and it also alleged FIR that the, the news number 1 namely FIR that 18 bags of rice were given that made FIR not has not any right from Secretary of last night Brahmat Saha cooperative is not submitted by Raman Bajaj. Who else was who are the other
Other accused persons, Angshu Datta and Akib Ahmed, Ashutosh Das, they have been also granted.
and the other co-accused persons, namely Angshu Datta, Neki Muhammad Das,
Ashutosh
and
Das,
Ashutosh Das,
Abdul Hassan,
they were also
arrested and granted bail.
Abdul Hassan, not not bail. They were in the meantime granted bail by which one?
by this honorable
High,
High
by the High. The person has submitted that cooperate the other has done each of has submitted the- for consideration for
On my lord, 25 one.
right of that April 4 were already were arrested in were already granted bail and the minutes that were directed their investigating officer of Nizam Bazar case 158 in a period of case and cooperate of because hearing bail of that subject of that by
One.
clients are saying that, my lord, I am giving consent and for every occasion and others, my lord, your lordship may look into this.
No.
Next, my lord, last occasion, here it is again written, PO is on training.
Legal bar is, unless I hear the,
Well, they are there. They are the person for the NCP. They are assisting the council. Why they are putting their name or they are assisting the council? Or they are now again 15 days, my lord. Again 15 days I will be behind the bar.
third,
Because the NCP council has taken leave for his own excuse.
no, otherwise bar is there. On 37 bar.
37 bar, my lord. And my lord, my here only not the delay in getting the bail. Another plea is of section 50. But I can show from the record. That is why I filed a 480 to accept it.
We are fixing it on third.
I don't,
You're paying for an
yes,
My lord, this is the problem, my lord, because every time now the client sees the order and they say that you are giving consent and why the court is giving that.
I have paid.
And my lord, this is the last occasion that they made.
Third, get away from. Third,
speak according.
after hearing from. Okay. Praise for. Count of council for payment therefore the grant of adjournment account their occasion. For had taken adjournment with case behind the bar now. As the statutory requirement of hearing public prosecutor their case for the commission on the and declare making very clear that no interrogation can be granted for the next fixed date. And next week, stop. Let this matter be. When should I fix it? He is okay.
Yes,
Let it get it out of there.
okay.
15 I am one.
Yes.
No.
Alauddin is 19.
19.
Alauddin.
Item 15 and 16 are Sushil.
Yes,
Sushil Kumar, sir.
Kumar
Sushil.
Sahu.
In this case, charges are not paid.
My lord, consideration of charges are done.
Okay, on the next date, you press that.
Because my lord, 3 years, 6, 11, more than 3 years. If the reasons are PO is on transfer, PO is on leave, PO is on training. Now the public prosecutor is on.
Third.
Left is a lot. 439 application, my lord. And today, my lord, 173 days, my lord. Petitioner is in custody, my lord.
173 days.
Tasted already, Master.
Charges submitted.
LCR is available. I have done. My lord, my lord, the PTO is under 21C commercial quantity matter. Tasted
What is
submitted.
your submission?
But here, my lord, nothing has been recovered from the position of the petitioner. He was, my lord, picked up from market, my lord, and he was leading to the house of the main accused. Where from, my lord, it was, my lord, I am in the district of under my lord Borpeta police station. I was sick.
Whether charges are framed.
No,
No,
I-
man.
and already my lord,
Charge-
the person my lord from whom my lord the contraband has been seized my lord, they have been released on bail. The other co-accused my lord, except my lord the main accused from whom the contraband was seized.
Who has been released?
Malat, in the Malat healthcare Malat, there is a Malat status report also Malat and a report from the court Malat. One Osman and one Suhail Ahmed. They were released on bail. Now they are not appearing. Case is fixed. Next day is
Why they were released?
Malat at that time Malat Malat charge sheet not submitted, but case diary was not up to date. There is one order of the Malat trial lower court. Next date is fixed on 3rd of January for their appearance. Malat. They are not appeared. They have not appeared on 2 occasions. Now,
No, they were released. But there were no material.
no. I am coming. I am not disclosing all the name Malat. One person was found Malat. One Malat. He is loitering in the Malat market.
No,
But-
otherwise, let me put query. My
Yes.
query is that co-accused has been released on bail may not be a
No,
ground
No.
for
Lord.
releasing.
Lord.
If there are material against you,
Lord.
you will not get any.
Malat, just Malat, I am submitting Malat. He was earlier arrested in another case, in same case, NDPS case, in Borpeta PS case number 7723. After releasing on bail, he is doing same act Malat. One person who is doing Malat vegetable business Malat, he sent truck to Malat, Silchar, and when coming back, he bring Malat ganja Malat. Heroin Malat, here heroin. Malat, Malat, one Afzal. From his home, Malat, 23 numbers of top case was recovered.
Afzal is the main
Afzal many cases. Afzal was not in Malat. Osman and other Malat. Three accused person Malat. To the name of this petition, Malat. They are all doing business in Borpeta Road area. Malat.
No, what is the allegation against?
Against him, Malat, one person is bringing those Malat and giving to
Present petitioner name is Ramesh.
Ramesh.
Ramesh my lord. FIR page 14.
My lord may go through my lord, that statement. My lord, 3-4 person, my lord. Mukhtar Sel, all the person take to the name of this petitioner, my lord. They are all doing business in my lord, Borpeta Road area, my lord.
Already you lost him my lord. Similar case told that my lord the mayor statement of co-accused my lord. 37 will not come. The position is not, is nothing found in the position. It was sort of
Mr. Parag,
My lord,
you have to show me what materials are there.
my lord,
Go through the case, right?
tag mark, already tag mark, my lord, LCR, my lord. My lord, fact is that, my lord, just recently it is succeeded in 29/9. Case is now fixed for appearance of the my lord, co-accused who were earlier granted bail. And all these persons, my lord, arrested persons, my lord, they are doing business in Borpeta Road area, my lord. Is of course, my lord, is a fund from the position of home of one person, Afzal.
Observe why the present petitioner was dropped.
From the statement,
Co-accused state.
statement. But he also stated, Malat may produce his statement also, Malat. And 37, Malat has to convince that, Malat, he is not doing such business after religion bail. He was religion bail in another case. after releasing bail, he is again doing such things, my lord.
I was not arrested. The main accused was arrested, I think.
Earlier accused himself, my lord,
Of the
Ramesh, 77 of 23. No, just one minute,
You
I'm-
go through the case there.
Hey,
Let him go through the case. They are on merit. They say that there is no material except co-accused state. You take time, not now.
my lord.
In the FIR itself, my lord, I was first picked up, then I was led to the house of the main accused. There, my lord, contraband was picked. I was picked up from market under Borbetta police station. Then occurrence, my lord, place of occurrence is at Howli, 15 kilometers away from the Borbetta.
His statement, my lord, আগতে ড্ৰাগছৰ ব্যৱসায়ত ফচি বৰপেটা থানাত 77/23 জেললৈ গৈছিলো। His statement, my lord. Thank you, Mr.
It has to be decided.
Yes, yes, my lord. His case has to be decided, but his conduct, my lord, after releasing grant of bail in another case, my lord, again he is involved in such type of case. So how do we believe this person that he will not do such act, my lord, after releasing on bail? And recent case, my lord, 77/23 Borbera PSP. This is Howli 120.
No, that is regarding second. Regarding first petition.
Yes, my lord, recovery, yes, recovery is not from him.
But he leaded to the recovery.
Yes, he led to the recovery, and all the co-accused 3-4 person, all are saying that we are doing such business in Borbera, along with all 3-4 person took the name of this person.
Okay, you flag market, I will see it
Well,
in last chat.
I-
That too I will dictate. You are
I
on
will not
merit.
take
If
my,
something is there in the case diary against you, you will not get bail. If nothing is
Lost.
I have already flagged my.
I can confirm, my lord, nothing will be here only except co-accused.
Ramesh, accused.
you take time,
No, I
take some time and
already flagged my lord, my lord.
that too I will dictate.
My lord.
All through flag mark here.
Okay.
I've got a of that. Okay. It should find the 24/11
Where you arrested?
arrested after 2 days of the FIR lordship on 26/11/2020 lordship. It was arrested on the basis of the co-accused statement lordship and no seizure or no recovery was from the possession of the present staff. And thereafter lordship of 31
What was the allegation?
allegation lordship for 408 kgs of ganja lordship from the co-accused lordship. He was a truck driver lordship. The truck was intersected
And during checking lordship, that was recovered from the possession of another person, lordship, the truck driver lordship. And 34 numbers of packets wrapped in a polythene was found concealed in the inside the vehicle in weight of about 408 kg. 34 packets, each packet lordship of out of 34 contains 12 kg.
No, read the operative the portion where the allegation,
Okay.
where the, read that portion where the allegation. Second paragraph.
Four.
Second paragraph of the FIR.
The suspected cannabis ganja recovered from the vehicle was subjected to feed in presence of above named witnesses. The net kg of the 408 kg I have been seized as per the serial memo following the procedure of the law in presence of two local witnesses. As mentioned, I have seized the following items in presence of the independent.
No,
Possible first page. Sir. On 24th November at about 4:30 p.m., a white and red color 10-wheeler LP truck.
this you were driving.
Not, I am not.
You
That
are
person who was arrested. I was arrested after 2 days. Sir.
okay.
And on basis of that statement of the
Okay,
arrested.
you were not in the truck.
No, I am not. I was arrested after 2 days. Sir. That I have clearly mentioned in that duty typed out. But 31/1/2021 lawsuit charges was filed with 9 listed witnesses. Sir.
No, in the FIR, your name is not mentioned.
No, Lord.
That-
No. Only forwarding report, Lordship, it says that, Lordship.
Where is the
I was
forwarding
arrested. Forwarding on page 13. Lord. The region of arrest, Lordship. During the course of interrogation, arrested prime accused, so and so, who was accompanied with during during transportation of the suspected cannabis and absconding during Naga. There was a statement of the co-accused. And after 2 days, Lordship, I was arrested, Lordship, on 26th. And incident occurred on 24/11. The prime accused was arrested. He was the driver of truck.
Okay. The statement is that you were also there in the
No, that
truck,
day on basis
but
of
you fled out.
that day on basis of that statement, Lordship, I was arrested. Okay, but no recovery, nothing was done for me.
Now you come to your truck.
Lordship, that chronologically, Lordship, on 31/1/2021 charge sheet with 9 listed witness were filed, Lordship, before the court. And thereafter on 23/8/2021 charge was framed. 23/8/2021. Thereafter 29/1/2022 the first PW appeared at deposed before the court. And till date, Lordship, out of 9 listed witnesses, 7 has been examined, Lordship, and the 7 was examined on 17/7/2023, Lordship, and till date, Lordship, no witnesses has turned up, Lordship, and last date, Lordship, was 19/12. Yesterday was the last date, Lordship, and that day also no witnesses has come.
Now, what is the evidence?
Because these are witnesses were not aware of me, Lordship. I was arrested after 2 days, Lordship. So they have not said anything against me, Lordship.
Now, out of these 7 witnesses, what is the evidence?
So nothing is specific against me. Because no, I was not present at the place of occurrence. Sir. Later on part, sir. They are part. No direct. Evidence.
Since when you are behind the bar?
26/11, Lord.
How
20.
many, how many days?
Lordship, as on date, Lordship, 1,120 days. Sir. 3 years, 24.
my lord, yes, my
You
lord,
have gone through the
dates already,
10 copy.
10 copies there, my lord. I have my lord, dates already, my lord, given, my lord. FR on 25, he was arrested on 26/11. Yes. Charged on 31st of January 21, first month. Now, my lord, yes, in the, my lord, LCR, my lord, here and is up to, my lord, last date of order is 30th of October. But he is saying about yesterday order, yes, that is not available. Yes, yes, Malat. So Malat, till date, Malat, only IO remain and another accused remain. Malat. IO is the vital, Malat. Other 7 Malat already examined, Malat.
For the PW7 appeared lordship on 17/7 lordship as per the LCR lordship 77 student he appeared and till date.
Yes. PW1 and PW7, I have tag mark, Malat, in between other Malat. So he was the Malat. As per the statement, Malat, he was the Malat who when of the Malat track, Malat. At the time of taking, Malat, he might have said it. Subsequently, you are arrested. And he is sailing from Manipur, Malat, and truck is coming from Manipur, Malat. 408 kg of ganja, Malat. FSL is proof, Malat.
Everyone has stated that the other co-accused has
Played it.
stated, but he has not.
Yes.
None of the Naka checking parties saw.
And that is IOS part is not vital, Malat. He has to be examined.
No, but the IOS case will be defended.
Yes, yes.
Otherwise, 3 years is too long.
Yes, but Malat, delay only now only IO, Malat, twice, Malat, someone issued, Malat. Why not appear? Maybe sometime in other place and maybe sometime during training and all this, Malat. Otherwise, Malat,
Since last
5 months, around 5 months, Malat,
no,
no witness.
uh, yes,
Otherwise, Malat, my submission will be, Malat, only 2 witnesses is yet to go, Malat. Let the trial be, Malat, as early as possible, Malat.
Yeah, yesterday also granted the data similar situated.
no,
The 9 were
NDPS
there.
cases, similar situation.
No, no.
not with-
Circumstances was there. 9 witnesses were there in
Your
I have
case is
annexed it.
otherwise strong.
I have annexed this one that order was it. That 9 witnesses were there, 7 were exempt. That was it to granted bail on 50 years. That I have annexed in the
Because this is only conditional liberty, not a
Yes,
hard Mr. S. Munir is certainly also hard KK Parat. This application for 39 of Court of Procedure for 1973 has filed W property state, right? Who has state and bar state seven connection created at state arising of type C list of where is the affair?
Page 10.
Page
Page 11 is the operative.
list of 25 7 1 M mutual proposed charge of Africa the type had lost the fire for the offset charge of reliability of their getting on receipt of a permit liable for that large quantity of suspected cannabis effect ganja coming from all types in truck bearing registration 801 East 856 and a Dhaka taking duty was conducted in front of the Africa at National Highway at and on 24 and on 2011 at about 4 p.m. White and red to the 10 meter speed truck carrying 8 0 8 by 6 was present with all types. Two persons were found on the state truck. State truck. And when the state truck was searched, state truck was searched, not 408 kgs of suspected ganja was recovered from the vehicle. Later on the basis of later on the driver and the helper of the driver of the state truck were arrested. How many accused persons were arrested?
Okay,
Only
here
driver.
only one lot, driver lot.
On the driver of the state truck was arrested, namely Sri Singh, who during interrogation has named the present petitioner as having been involved in the offence alleged in the FIR on the basis of statement of co-accused, the present petitioner was arrested on 25th of Learned counsel for the petitioner has submitted that thereafter, after that on the basis of the said FIR, the LIPS case number 48/2020 was registered and investigation was and ultimately on completion of the investigation, on 31/1/2021, charge sheet was laid against the present petitioner and the co-accused with 9 prosecution witnesses listed in is further submitted by the counsel for though on 23/8/2021 charges were framed by the trial court. However, till date, in spite of the fact that the petitioner has been detained behind the bar for more than 3 years, all the witnesses are yet stopped. It further submitted that though 7 of the 9 witnesses have been already examined by the prosecution side. However, none of the
No, my lord, PW number 2, my lord. 2 says that there is 2 person, my lord. In main, my lord. Not in the deposition, PW number 2, my lord. In the second page. In the second page of his deposition, my lord. First, fourth line, my lord. When the truck was stopped at the council gate, 3-4 police personnel ran towards the gas. Then the police personnel searched the backside of the truck, removing the truck people and found 34 numbers of packets wrapped in the polythene package. There were 2 persons in the truck. One was the driver, one was the handyman. Today I have identified both of them for in the death.
but that is not the case. He was not there. Let me check it up. He has submitted that none of the witnesses have implicated the present petitioner in the case. Learned counsel for the last witness to be examined the case was on 17/5/2023, and since then prosecution side has failed to produce any further witness for the prosecution side. And it is unlikely that the trial would be completed. You have relied upon certain rulings of learned counsel. Is further submitted by learned counsel for that petitioner is entitled to get bail due to prolonged incarceration as per the observation of the Apex Court. In Ravi Prakash versus State of Odisha, in bracket order date 13 Ilyas Sen, State, in bracket, city of death, quoted in sub city of life, S3 5, where it was observed by export that the prolonged carceling overrides the embargo of Section 37. Planet. What is the guarantee that we get Learned Counsel for the petitioner has also submitted that though the petitioner permanent resident, he would be appearing for the trial court case. On the other hand, that petitioner has opposed the grant of bail petitioner on the ground that quantity of contraband in this case is 408 kg, which is commercial quantity, and therefore the embargo of Section 37 of the Civil Act is applicable. He has further submitted that already 7 witnesses have been examined, and though last 2 occasions, on last 2 dates, 6 were trial court, the side has not produced any. However, considering the fact that only 2 witnesses are to be examined, there is unlikelihood that trial will take long time for completion. And on that ground, he submits that he opposes the grant of bail present petition. Opposes the grant of bail to the present only the ground of long search. I have considered the submission made by learned counsel for both the sides and have reviewed the scanned copy of the case record of NDPS case number 19/2021, which was called for in connection with though the case involves commercial quantity contraband, which is also a huge quantity, 400 feet. However, considering the fact that the petitioner has been detained behind the bar for more than 3 years, the question before the court is whether the period of detention during which period of detention of the present long enough so as to outweigh the embargo of Section 37. And if this court comes to a finding that the delay is long enough so that the embargo of Section 37 of the NDPS Act outweighed by the fundamental right guaranteed within Article 21 of the Constitution, he may have been released on bail in spite of the embargo of Section 37. It appears from perusal of the scanned copy of the case report that the petitioner not at all for the delay prior in this case, as he was all along detained behind bar throughout the trial. The petitioner has a right to get speedy trial. Then code 14, 15, para 14, para 15, 17 from the bail application of 385. Thereafter, right, Senate counsel for the petitioner has also cited a ruling of Honorable Apex Court in Tapas Mandal for the state of West Bengal within bracket order dated 14/9/2020 in special leave to appeal in bracket criminal number 8464/20, as well as another ruling of the Apex Court in Mon Mandal and other for the state of West Bengal within bracket order dated 14/9/2020 in special leave to appeal within bracket criminal number 8656 wherein the Apex Court has allowed the accused person to go on bail in spite of the fact that they were facing charges for possession of charges under section 21C/29 of the EPS Act 85 on the ground of the on the ground that they have been incarcerated for a period of almost 2 years and the trial is not like taken for immediate effect. In the instant in the instant case also, though the petitioner has been detained behind bar since 26/7/2020, though the charges were framed on 23/8/2021, the prosecution side has yet to complete, has not yet reduced the evidence of all listed prosecutions. It also appears that even the last witness which was examined by the prosecution side was examined only 5 months ago. Under such circumstances, this court is of considered opinion that there is a likelihood that the culmination of trial would take some time, and under the facts and circumstances of the case of the present, this court is of considered opinion that the long incarceration of the present for more than 3 years in this case has outweighed the embargo of Section 37 of the NTP Act. Hence, the petitioner that get bail. Court Terana. Petitioner is allowed to go on bail of petitioner is allowed to go on bail of 1 lakh with 2 security, and one of the security should be a government security, and with some other conditions. this of the bail application had
That's also clear. But the context side
400
work
You-
per annum.
no. So the petitioner set up for it before. However, considering the fact that huge quantity of ganja was seized in this case, this court proposes to stringent of bail. Therefore,
Much obliged. Much.
The party is fair for it.
he that
Opposite party is fair for adjustment. So there
you have no
is no objection because the lordship would not hear.
verbal court.
No, on our last K. Roy Chaudhary's case, which is noticed that
Yes, because there is a legal I have yet our Mr.
therefore
A. Paul that is also our Mr.
Speak up.
P. Kakoli that is council appearing for the care standing of the praise for German state due to personal efficacy of considered now declared that the death is registered again in first week of
11
11 of
fixed
Yeah.
on 11th of January.
For certain application, paying for bail of the accused petitioner who was in connection, who was arrested in connection with Kalkasia PS case number 160 of 2023, on 9
There is there
11
Yes,
23.
there is.
yes.
Township is behind the for more than 41 days. The FI is in case number 9.
Yes.
May I read the word? With due respect, on 8/11/23 evening at about 6:30 p.m., when I was not in my home, accused number 1 hired the other accused person and after entering into my house unauthorizedly tried to take away my wife, Simon Netta. When my wife tried to get rid of the person, accused person number 2 wrapped her neck by a gamusa. The accused person number 1 a knife in her left hand and injured her. Later on, the accused person blocked my wife's route and tried to put her into the four-wheeler car bearing number so and so brought by the accused person number 3 and 4. After hearing the screaming of my wife, the local people came forward, apprehended the accused person number 3 and 4 along with their car and handed over to Baliguri outpost. Thereafter, the accused was admitted to Bopeta Civil Hospital, Kolkata. Here I'm the driver, and my vehicle was hired by the accused number 1. And accused number 1, the informant is the brother-in-law of the accused number 1. There was a family problem there, and the accused number 1, was granted anticipatory bail by this honorable court on 4/12/2023.
Where is the order?
I have not annexed.
No, the allegation against the case number one that he hired
No, so I'm a driver by profession. My vehicle was hired. My driving license, I have annexed in case number 8, the transport driving license. And point number 7 of the order may be kindly paid. Perusal of the case diary indicates that the IO has achieved sufficient progress of the investigation of the case. In view of the above, and in view of the submission of the learned advocate, the custodial detention of the applicant seems not to be warranted here in this lordship. The sufficient progress has been achieved.
Yes, no case they received, my lord. He is in jail for last 41 days. Otherwise, my lord, he is associated with Abdul Ali. Because owner, my lord, Jogeshwar Talukdar, he is also an accused in this. He, along with the main accused, tried to kidnap the victim. He is in jail for from 9/11.
9/11 to 20.
but I'll declare that to हाँ लोग तो कहते it
9/11.
9/7 for last it's stupid. That 9/11 one Abdul Karim and not for that what was the there what is your name? Abdul Karim
Shahjahan.
Shahjahan number 2 that name file name including that at of or right take of it wife of and of wife God your it it bad it was 3 4 name it file where we by where and it by the local public and where ended the council for submitted for the driver of vehicle is A and 0 Q 6 and his and said vehicle was hired by
Abdul Ali.
the accused number 1 named Abdul and he not for offense alleged in the FIR Learned counsel for the petitioner has also submitted. In the meanwhile, main accused Abdul has already been granted bail by coordinate bench in AB case number 3936 by order dated 4/12/2023. Learned counsel for the petitioner has further submitted that considering the period of detention within bracket 41 days already undergone by the petitioner, he may be allowed. On the other hand, learned additional purpose there that additional purpose has produced the case diary of Kolgotia PS case number 166/23 and has submitted that there are incriminating material against the president and any other.
And my lord, the present accused person has requested in her 161 statement also she stated that someone has cut her neck by using a gamusa and that complaint is also made regarding Shahjahan Arbi while at the time of kidnapping her. The present accused person caught in her neck. That is 161. That is the statement of the complainant.
She named Shahjahan,
No, she not named, she only named Abdullah.
then against Shahjahan,
Shahjahan, my lord, that is the statement of the, my lord, that is in the FIR, my lord, allegation. It is specific.
someone has got specific name.
Yeah. And she also, my lord, one injury report is available, multiple scratch marks on left arm. See, my lord, victim.
Learned counsel for the petition, learned additional purpose has victim that is the white got scratch mark with left arm.
Yes.
So the injury report away.
A final report, no, it is not final report, madam. That final report will be given by, so and so, it is my preliminary.
Considering the I have considered the submission made by my counsel for both sides and have reviewed material for including case study of Kolgotia PS case number 166/. Considering the fact that main accused case are paid by coordinate bench of as well as considering period of progress further appropriate does not appear fair competition of the CFX and stop in view of the above, petitioner Shahjahan allowed take up 20,000 corporate with available.
Okay.
Mr. Parakar, these statements are general statements that he used to.
Yes,
The
not-
question is
not specific.
not
against-
specific as regards
against
the
case.
this contraband. So for that they cannot be. He might have been indulged in.
Yeah, yes.
Otherwise, there is nothing apart from.
But regarding his conduct, that he, he was, earlier also,
Earlier arrested and acquitted by the trial. I reported that in the December.
That
He
may
was
have.
instigated, my lord, by 29. It is-
Look,
By adding 29, my lord, he was arrested. In this case also 20.
heard with the heart that it that it also heard take it for that it this application the 439 Board of Teachers of has been filed by the petitioner named Ramesh Chandra, who is detained behind the bar, who has been detained behind the bar since 10/7/2023 in bracket for last 170 days in connection with what is the this special case number
Special case 6-1, 2023.
in connection with NDPS case number 61 slash pending before the court of sessions judge court. It is of the case that on ten seven 2001 Niranjan Das had got fire for the officer judge Howley. Now in FIR, what was the allegation against you?
Against me, my lord, information was received against me that I was loitering in the market. And I was arrested, my lord. Thereafter, my lord, another information received that some contraband is kept in the house of the main accused, my lord, Afzal in the house. So I was arrested and I was taken to his house. It's 14 months.
That present of the number of number of the is has been running illegal business of drugs and accordingly present of the who took the police out of OAQ after from where 30 numbers of soap and was picked up. Weight of doing was found to be
99.88 is 15. With my lord plastic soap paste.
out that
So it was not
in the that found to be 939.88 grams along with plastic soap on the tip of the FIR of the not with that he that he must be that 29 and investigation ultimately after completion of the investigation, charge sheet sheet was laid. Charge sheet was laid with how many accused persons?
My lord, till
Where is the charge?
Shastit Malata. Yeah, but
Charge sheet was laid with yes,
During pendency of this case, so you could not
29/9/20. Shastit on 29/9.
charge sheet was laid on 29/9. Okay.
charge sheet laid, my lord, against 8 accused.
Against 8 accused persons. The section 21. Learned counsel for the petitioner has submitted that though the petitioner has been, how many are on bail out of 8?
To except main accused part. Others are not.
Learned counsel for the out of the 8
After
charges
one.
accused persons, except the main accused.
Mukta.
What is the name?
Main accused, my lord, Afzal,
Afzal, my lord.
Afzal.
From whose residence?
Main accused Afzal and the present all other accused persons are learned counsel for the petitioner has further submitted that the petitioner no for offense alleged the FIR as nothing but it from and the only incriminating material are statement of poet is also submitted by the petitioner had only shown the precedent of any accused
Many.
observed to the put. And apart from that, he has not shown. On the other hand, an additional of the prosecutor has submitted that the co-accused have implicated the present petitioner in this case and have made statement that present petitioner used to indulge business of legal prohibited drug forfeit act. is also submitted by the petitioner was earlier arrested in connection with another case involving prohibited prohibited drugs.
In the
On this, learned counsel for the petitioner has submitted that earlier the petitioner was falsely implicated in a case involving contraband of intermediate quantity, in which charges were framed against the present petitioner under Section 21B/29 of the NDPS Act. In NDPS case number 17/2020, however, by judgment and order dated 1/2/12/2023, passed by the Sessions Judge Borpeta, in the said case, the present petitioner has been acquitted by the trial. I have considered the submission made by the counsel for both sides and have perused the case side of perused and copy of the case side of how the case one side and as well as an copy of case record of Sessions case record of NDPS case number 61/2020 pending before the Court of Appeal. As in as apart from the statement of co-accused, there is nothing which nothing about which implicates the present petition. Either of the how much either of the what was what was the quantity?
99.88.
And of
Zero.
of the heroin is in this case. And as well better in the packet of packet for state but to with I do not quoted 20 with as well as Tufan Singh versus State of Tamil Nadu reported in 2024 what where it was held that the corporation recorded and value of such help remains so that is inadmissible in even at stage of state, and therefore in this case as there is nothing except the statement of the co-accused as well as statement. For the purpose of considering the way that this court is considered opinion that there are reasonable grounds to believe that petitioner is not guilty of offense charged, offense alleged against him. Therefore, the embargo of first part of the section 37 of the NDPS Act not applicable. As regard the possibility that he is not likely to commit offense while on bail, though Learned has pointed out that was earlier arrested in connection with a similar case. However, in view of the fact that in that case the petitioner has been acquitted by judgment dated 1/12/2023, passed in NDPS case number 17/20, by Learned Session Judge, there remains nothing on record from which it can be said that there is a likelihood of commission of offense of similar kind by petitioner PP. Therefore, the court supports that embargo of 2037 of this act not applicable in case of as except the main accused namely observed that all other accused persons are released on bail, and as embargo as stated above that the embargo of the not applicable in the case of the petitioner allowed to go on bail of 50,000 with satisfaction of Learned Session Judge court. 50,000 is 20 following that petitioner had not received death certificate. Where do you say
Kolkata.
that there is the second judge Kolkata without prior leave from the Learned Session Judge court? If the petitioner cannot directly or that any person back from disposing any fact or from disposing against it pending in the case in the NDPS case number 61 pending before the court of the session. The petitioner shall not indulge in any offense of similar kind with which has charged with above observation with bail.
NB 2020, the petitioner was not approached started court. Court had application consider condition may be can be appear and take out.
No, you pray before
Yes, sir.
because non-bailable warrant have
arrest.
He has not filed criminal revision. We'll visit.
You are arrested.
He has already arrested.
Or page number 20.
On the strength of NBWA.
Let him get heard, Mr. F. of Learned Counsel for God, the three board of Learned Petitioner for this application the section 439 of 439 of Code of 1973 has been filed by the petitioner Nipen Sharma alias Nipen Chand Sharma, who has been detained behind the bar on the strength of non-bailable warrant of arrest issued against him by the Court of Learned Judicial Magistrate First Class Borpeta. How, since when you are detained?
8/12/20.
Borpeta. Learned counsel for the petitioner has submitted that the petitioner has been facing a trial of a case under section 138 of the Negotiable Instrument Act 1881, which was registered on the basis of a complaint filed by one Damayanti Pathak. It is further submitted by Learned counsel that in the same case, that is NI case number 60/2022, the petitioner had appeared before the judge and was allowed to go on bail. However, later on, why you defaulted?
There was some discussion between them. With the lordship at the ticket was grantor of person is person.
No. Why you defaulted?
Lordship was out of state for his job lot.
You must have, should have. However, he defaulted in appearing before the Learned trial court on the date fixed before the Learned trial, as he went out of station for his life gift. And in the meanwhile, the Learned trial court issued non-bailable warrant. It is submitted by Learned counsel for the petitioner that there is a talk of compromise going on with complainant as well as accused person, as well as the present petitioner in the pending NI Act case. It is also submitted that the petitioner shall cooperate in the trial if he is allowed to cooperate. You have any as this is a private complaint case, Learned additional public prosecutor may make and as well as on the ground that the Learned counsel for the petitioner has made sufficient that the petitioner shall appear before the trial court face trial. Learned public petitioner make no objection that grant of bail. In view of above, the petitioner is allowed to go bail of rupees 30,000 once he receives back, subject to satisfaction of trial court, that is petition first class court. Petition that petitioner shall regularly appear before Learned trial court NI case 60 as that state
apply. Conditional sentence is page number 82 of 3 are the simple imprisonment under section 457, page number 32. Uh, 2 years right is not payment. Method 30, that method
I heard Mr. M.J. Kadir Planet Township, but also heard Mr. P. Bhatta. This appeal has been registered 374 that within bracket 2 of the court of 90. This appeal has been by the appellant under section 374 within bracket 2 of the court of impugning the judgment order dated 1/12/2000 passed by the Regional Second Judge Hyderabad, second case number 79/20, whereby the present appellant was convicted under section 457 of the Indian Penal Code and was sentenced to undergo simple imprisonment for 3 years and pay a fine of 55,000 and in default of payment of fine to undergo further imprisonment for 3 months. The appellant was also convicted under section 457 of Indian Penal Code and was sentenced to undergo rigorous imprisonment for 3 years. Now, also instead of 354 and was sentenced to undergo rigorous issue notice to the respondent and call for the case record of session case number 79 of the that the appeal is submitted for the appellant shall take steps for issuance of notice of respondent of the by registered to be taken in 3 days from the date of the order returnable after court. As regards respondent number 1 is concerned, as learned additional public prosecutor has appeared, no formal notice need to let this matter be decided after court. IA, what is your ground?
I am either found that the actual practice of the defense of the victim had some method transaction with the petitioner. Out of that, my lord, this case is filed, my lord. My
No,
lord,
where is the defect in
all the 3, my lord, witnesses, my lord, victim, husband, and my lord, victim. My lord, the PW2, the husband sister stated that, my lord, in the same compound there are 5 families deep, my lord. But my lord, one of the witness, my lord, PW3, my lord, of the adjacent house, he stated, my lord, in the annex, my lord, that he do not know, my lord, anything on happened on this day or thereafter on another, my lord. PW4 was also an independent witness, my lord. I have annexed, my lord. He also, my lord, did not mention that anything happened, my lord. He is a neighbor, my lord. And this is make out case. You also mentioned that, my lord. He
heard Mr. M.J. Kadir done something for applicant. Also heard P. Bhatta, the teacher for this application 389 court of application has been filed by the praying for suspension of execution sentence imposed on appellant by the judgment and order that one whereby present applicant was convicted under section 457 Indian Penal Code and was sentenced under simple for 3 years and was and also pay fine of 5,000 and in default of payment fine to undergo further simple 3 months. The applicant was also convicted under section 354A of the Indian Penal Code and has been sentenced to undergo rigorous imprisonment for 3 years. The applicant has impugned the aforesaid judgment by filing a connected appeal which has been registered as criminal appeal number 473/2000, which is admitted for the Learned counsel for petitioner has applicant has submitted that the Learned trial court has heard it coming to the finding of conviction of guilt of the present applicant on the basis of evidence of the process. Though the independent prosecution witnesses, namely PW3, PW4, who are the neighbors of the present appellant, who are the neighbors of the victim, where the alleged incident occurred, have not implicated the present appellant. Learned counsel for the petitioner has also submitted that there is every likelihood that the appeal filed by present appellant impugning judgment passed by an additional signature on 1/12/23 may be allowed. However, as the may be allowed. So, considering the submissions made by Learned counsel for, you have anything to say? Priya?
I only that it can be called.
So, Learned petitioner public prosecutor submit that the no, he has annexed the so Learned additional public prosecutor has submitted that the LCR may be called for, however, as the photo as the copies of the testimony of the prosecution witnesses which were adduced, which were recorded during the trial, has been annexed along with the interlocutory application. Hence, for the purpose of consideration of the instant interlocutory application, this court is of considered opinion that the result of the LCR may not be more so as the conviction is only of the only for a limited period. The sentence imposed is only for a limited period of 3 years. And if the and considering the number of appeals pending before this court, there is every likelihood that disposal of the connected criminal appeal may take some time. Therefore, if the sentence imposed on present petitioner not suspended, there is a probability, there is a possibility that the petitioner, that the present applicant may be prejudiced in the event of its in the event, if, in the event of it appeal it being allowed and sentence in the impugned judgment being set in the event of setting aside of the impugned judgment. And therefore, in view of above, the, you are not on bail.
Bail,
Yeah.
my lord. I have annexed the order, my lord, page number 36. At the current trial court, suspended sentence, page number 36.
You are on bail.
Yes. Page number
The
36.
petitioner is therefore allowed to remain on previous bail granted to him by the learned judge by order date 1/12/2020, case number 79, that and execution of sentence imposed on present appeal shall remain suspended during the pendency of connected criminal appeal, that is criminal appeal court of last. This interlocutory report
My lord. Have the- the doctor from the exit for two. All the experts were arrested on 27/11/21, day 753 days, my lord. Allegation 805 grams of heroin recovered from their custody, my lord. And then, my lord, all the experts deposed before the London trial court, my lord, they are bail for bail. It has not been considered an expert one for the perusal of the records, my lord. Certified 3 out of 7 witnesses to be examined, recorded by the trial court, and except for one. So that thereafter, presently,
Where is the order?
I have annexed it. Page annex of 5, page 13, 30. Jamil Ahmed. 612 page.
He is the co-accused.
Yes, my accused number 1, my lord.
And you are?
2.
How many accused are there?
3, my lord. He is accused number 3. Altogether 3, my lord. 1 already.
Listed has come. The long order.
Page 30. Service.
Yes, Mr. Parag. One of
My
the
lord,
accused
yes.
has
I have
been
gone
released.
to my lord.
One of the accused has been released.
One release, my lord, but my lord is not bound by that order, my lord.
No, but he is
Yes.
the co-accused
That
and
is
on
fine, my
long
lord.
incarceration. And he has been released when?
On
In the month
1/8/23.
on 1/8/23.
612.
And how many?
Total fee, my lord. 3%.
What is your name?
My name is Joram Mawa.
Well, that
Accused number
person is from Assam and other 2% from Mizoram.
Zoram has been detained behind the bar since
27/11/20. Same day we were arrested.
27/11.
21.
And how many days you have?
753 days.
And you are for? Same day arrest.
Same day.
And
Malak-
same
3% coming in a car, Malad. Police on Naka checking, prend him and then the police and BSF team asked the independent witness from shopkeepers were there, and one of the shopkeepers searched one police officer. He found nothing. PW1 is the Malad person, and then police searched in the vehicle where he found Malad 45 numbers of shop case, total weight 1995 with shop case,
without stop case 605
Gram.
and 605 gram. And these are my lord, positive FSL positive test for heroin. And PW1 my lord, one first of examine on 1st of March 23, PW2 on 18 of May 23, and PW3 on 2nd of June 23. 2nd of June 2623. But since 26, not none has been examined. Nobody has. That is the fact. But one my lord, PW1 my lord, those my lord, Caesar witness, he himself says that I have searched the police person. I have found nothing. And then in front of him, the police person searched the my lord, vehicle. In the vehicle,
In the vehicle.
all the 3 person were
No,
coming.
there may be
Yes.
materials against them, but trial is not progressed,
Trial is not present since 26.
and one of the co-accused has already been tried.
That is my lord, but heroin my lord, commercial quantity of
Therefore, trial has to be like in a fast pace.
total total there are my lord, seven witnesses in the
Sir,
charge
there-
sheet, 7 witnesses. Out of 7, 3 examined.
And whether they have implicated,
Yes, my lord.
they have
They all are Caesar witness.
now whether the person who is enlarged on bail is facing trial, is coming,
Kabir Ahmad Parakuma instructed Malad he is appearing.
He is the counsel may not.
and suppose you are released on bail, what is the guarantee that
That person is from Malad Karimganj. And these 2 persons are from Mizoram.
In this regard,
That is
I like to derive have conditions imposed here. The first condition very clear here, my lord, that the petitioner shall not leave the territorial jurisdiction of the Lord Special Judge Karimganj without prior written permission from the if under condition, my lord, the petitioner shall furnish the present residential address with
Third.
proof.
Malad, one may be Malad local witness because
Yes,
local.
third, Mr.
PK.
P.K. Dekha, and counsel for also heard the K.K. Parashar petitioner for this application of Section 439 of the Code of Criminal Procedure of 1973 has been filed by the petitioner, namely Zoram Mawia, who has been detained behind the bar since 28/11/2021 within the for last 750 days in connection with
Katawari PS case number
in
57.
connection with special NDPS case
Special
number 120/2021 corresponding to Ratawari PS case number 573/2021 pending before the court of Learned. Which court?
Learned Special Judge Karimganj.
Special Judge Karim. The list of the learned counsel for the petitioner has submitted that the present petitioner is facing a trial for alleged possession of commercial quantity of contraband, that is 605 grams of heroin, along with other 2 accused persons, namely
Jamil Ahmed, my lord,
Jamil Ahmed
and another is my lord,
and Lal Thana Saib. However, Lal Thana Saib of Learned Counsel has also submitted that in the meanwhile, one of the co-accused, namely Jamil Ahmed, has been allowed to go on bail by a coordinate bench of this court by order dated 1/8/2023 passed in bail application number 1996/2023 and the present petitioner is languishing behind the bar. It is also submitted by the counsel that till now three prosecutions have served out of 7 listed prosecutions. There is every likelihood that the culmination of the trial against the president could take some time. Then quote paragraph number 7 from bail application number 3 is 5 paragraph. Learned next learned counsel for the petitioner has submitted that though the present permanent resident of state of Mizoram, he would face trial and shall cooperate in that is if he is found. On the other hand, learned additional public prosecutor has submitted that the co-accused who was allowed to go on bail is a resident of Assam, whereas present is a resident of Mizoram. And further, there are incriminating materials against the in the on record stuff. He also submits that as the quantity of contraband that is 605 grams of heroin is of commercial quantity, and therefore the embargo of the comes into play, and therefore on that ground he opposes the grant of bail present petition. I have considered the submissions made by the counsel for the learned counsel for both the sides and have perused the scanned copy of the case record of NDPS case number 120/23. 753 days comes to how many in years?
24 days.
2 years. That is more than 2 years. Then quote paragraph number 12 of the bail application 385. 3852 is titled para 12. Para 13, para 14, 15, 16, 17. Then in the instant case, petitioner has been detained behind the bar since 27/11/2022. That is for past 700 days. And only 3 prosecution witnesses have been established. There is every likelihood that culmination of trial would take some time. And under the facts and circumstances of this case, this court is of considered that the long incarceration for more than a year has outweighed the embargo of Section 37 of the NDPS Act, 1985. Now, one of the co-accused has already been granted bail by a coordinate bench of this court on the ground of on the ground of long incarceration. Therefore, this court is considered that the petitioner entitled to get bail in court that 1 lakh with future, 1 lakh,
One
one of the along with some
last portion maybe मतलब the date of arrest is 27/11/21 maybe the date is
date of arrest
27/11/2020.
11 with above. What is your case?
All same मतलब only
Same or same order?
Same order, ma'am.
but
Same or
Number 4.
arrested along with that fellow and
name
his
will be
name
entered.
name may be changed.
Name of the
Names are
council.
different. Yeah, different.
This is production list for production item. Name of the council, name of the petitioner put it. And
This is from Mizoram.
I'm also from Mizoram.
He is also from. He is also
everything-
Take your
MS was
take your
Wait, Vijay. 439 application, 21B, man. Yes. Already 60 days, man.
60 days,
Yes, today is 68 days. 68.
then
Well,
you will
yeah.
get
मतलब I have obtained instruction मतलब till मतलब शासित no.
cash in hand. So he said that
Two petitions.
heard
Intermediate for
Mr. S.
21.
Das, then council for the also heard Mr. A. K. Parashar, then additional public prosecutor. This application under 439 of the Code of Procedure Command has been filed by the petitioner, namely by the petitioners, namely Kunti Lata Manji and Mamta Tarai, who are detained behind the bar since 21/10/23.
But after that, I take with her baby 4 and already.
21/10/2023 within bracket for last 60 days. Stop. The counsel for the petitioner has submitted that petitioner number 2, that is Mamta Tarai, has been detained behind the bar along with her
4.5 years old.
4.5 years old baby. The list of accusation in this case is that where is the affair?
One FIR, my lord, is at page number 40.
That the
176 grams.
that on on 20/10/2023, one Vijay Kumar Singh had lodged an FIR before the officer in charge of New Bongaigaon ERPS slash Investigation Center, Bongaigaon, inter alia, alleging that what is the quantity?
176 grams suspected brown sugar.
Inter alia, alleging that on the basis of a secret information received with reliable sources, the GRP a search was conducted in coach number S7 of the train number 14619 Tripura Sundari Express, and during search operation 176 grams of
Heroin.
heroin was seized from the possession of present petitioner. The council for has submitted that the quantity of contraband in this case is less than commercial quantity. And therefore, the statutory period of detention under Section 167 clause 2 of the Act is only 60 days. And today is 60th day of detention. And hence, prayer for bail is, and hence it is prayed that petitioners may be allowed. On the other hand, an additional public submits that it, as on date, he does not have any information as to whether charge it has been taken.
No, no, matlab, as per the telephony instruction with the Ayub, with our clerk, matlab, no, sir.
Charge sheet has, no. He has been informed by the investigating officer over telephone that no charge sheet has been laid with him. And therefore, he also does not oppose the grant of bail, considering the period of detention already under control. In view of the submissions made by the counsel for both sides, as well as in view of the fact that as well as period of detention already undergone by present petitioner, both the above named petitioner are hereby allowed to go on bail of 30,000 each with one surety of like amount, subject to the satisfaction of the special judge Bongaigaon. With following conditions. With this observation, and with a
Highly obliged.
24 matlab city not city.
what is
Petitioner to petitioner.
out, Mr. Dean, Dean, then counsel for God, pray for another day, some more time to produce. Let it matter.
Matlab on 19 matlab.
No,
Well,
after
three-
3 weeks,
three.
after 3 weeks, interim or just for 3 weeks.
My lord, here interim was granted on my lord 24th of August 23. It is asked my lord, as my lord, per the IO note my lord on 29/11/23. He has not appeared before the IO.
Drafting that in page. Petitioner has appeared 3 occasions. Bail order has been given, but not recorded.
My lord, in that case, my lord, he has already said that back to me, my lord. My lord, I advise that you may file an affidavit, my lord, without that, because we have to go by the CD. If saying that, then my lord,
And thereafter, it's as per direct. Not recorded. It like that. Not bail order was also not paid on by
12
No,
internet and from it that not yet. It appears that
as per
it had not yet paid,
till matlab 29/11/20.
not yet it uh, paid for joint and fire and bring it back.
it that
After the
Petition by the first week after the first week after
month.
the it had the
unappeared.
non-appeared for the petition for the state of
For 30th of interim method, where is 14
TT has been followed. But if the
notice of
offense is noted, other three accord.
your own
interim. In the last occasion, my lord, yes, there was fair. Lack of I was in interim.
after Peruthala
Kindly see the order dated 4/10.
then after Peruthala by Srinivas, why not
Perhaps the statement was not recorded. Therefore, it was
now statement heard no don't want heard
H.
H but appearing
written account is CPA.
as as inner count not submitted by the report for some any paid on or in sub by this and for direction as care and as corporate that is not
Written
special count
written account is comes with the purpose.
done at special purpose CPA has produced case diary of the
RC
RC number
1
17017038 and correct complied with the act by this by court made that that design
correct.
Item 30, my lord, case diary not received. Petitioner is on interim.
Third, Mr. Third, Mr. A. Chaudhary. Third, Mr. A. Third, Mr. R. Third, Mr. R. And township was also heard. He brought up submits that to the case of praise for the board.
On 25th of the
In the second week of
Yes.
second week of the interim on cap
P1 also, my lord, case diary not received.
Earlier there was, yeah, there is a order of the put it, that I did it that
is that it not
Case diary not.
there was a direction within
Lord.
I will have to get the instruction from
third Mr. L. R. Majumdar. That author a the P bottom submit that low that submit that case that not available. Verify from the that after
after
second that third week of year interim on
not
no interim. Then when you want
hard otherwise I have problem.
okay
Yeah.
third week of
But the price was that it are paid because it actually 376 is not affected with it, only attempt is there, and that the one lady are paid. In fact,
AB is there.
lot. Petitioner number 2 is
Whether-
the lady lot. And it is a attempt lot if not
But-
if,
It's a
Not-
like
lot if, but there is no ingredients of 376.
and my lord, fixed it on 4th of January.
I'll put part.
okay.
Yes.
We consider
Like
42, my lord, 36 of the CS number. None appear clear.
yeah. Identification.
255/23 dated 30/10/20.
You of that 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 but
33, my lord, also case diary not received. Petitioner is on interim.
third of thought support like third week of that is what
Yeah, but it
It is available, ma'am.
but not first like made this is first it not cross affair. First affair was lost in the bit.
My lord, he is seeking bail in Kokamok PS case number 10223 and cross affair is 10423. 104 already succeeded, ma'am. So that city, both the city was solved. Now 102, where he is seeking my lord bail, that city is available.
So, right. My lord, type of it is page 40. May with it effect to inform you that
No, before you did, what is the date?
it that on my lord 5/10/23 Tapar with the center was from Subansiri. In the meantime, the district administration has allowed stop tracking standard status, but that the same appears that it is managing the forest part, they continue to allow the tracking stand. And petitioner is the my lord is happens to be the joint secretary of Ishak Mukti Sangram Samaj. Seeing this my lord illegal activities, he and the colleague has intervened my lord that part, that part. In the meantime, they called upon some media person and also the forest department officials arrived there and having some compromise with the dumper driver, they allowed to go the driver from the. And in the meantime, they have called some media by the PT that revealed that the fact that this critical center and gravel extract is doing. In the meantime, my lord, when media persons are taking interviews for this, my lord, 10 mafias with 15 to 20 members, they came to the to recover the number from the my lord, piece of this my lord, petitioner and four police, three police. They attacked this my lord petitioner as well as other people. Also injured some media persons. And they caught some Papu Deka, that is my colleague, to the my lord, they abducted, and thereafter they handed over Papu Deka to the police.
What is the name?
My name is my lord Durga Pola. And Papu Deka was my lord released from the my lord police station. He was not arrested, but subsequently 2 members of my colleague my lord, they were arrested. I am not my lord. I am now and last. So this is my case, and thereafter, since my lord, they have attacked us on behalf of my lord, the state of the district and of the both resources that they have attacked.
If you cross the fire,
Some of the
justice,
fair-
That is succeeded. That is another thing. My lord.
That would reveal my lord what happened. So petitioner is not my lord, because
no, what is the allegation?
allegation is extortion from 68 extortion that from we are collecting some illegal my lord, money from the company that and also allows that 20,000 were looted from the my lord drive. This is the simple.
My lord, they being the member of a Yes.
What was the charge? allegation that
That is my lord cross case. Cross case, that is my lord policy of number of sections. Kindly
No,
find
no.
a page.
Don't go for
My lord.
this. What was
Here, my lord, that this 10 mafias has
They have attacked.
Yes, attack, and one of the feet of the Pappu Dekka was my lord deadly attack. His skull was broken.
Dekka was victim in that.
Yes, victim is my colleague.
Now, but
My submission is that my lord may join and this can mafia who have caused the my lord affair against me. So he happens to be affiliated with the party and this is solely out of my lord political rivalry. They have implicated my name, my I may be mistaken. I will appear to the
what has happened? Those were
they have already been four parts, including the Pappu Dekka, my lord.
injured.
Yes, have this my lord incident was happened previously that we have demanded money or that we are the habitual my lord looter from the dumper. Then Pappu Dekka, why should he been released from the he is released.
Yes.
Then another two was caught and arrested, but released after my lord 10 to 15 days. I have ordered.
What is
Yes, yes.
Name?
One is sent to my lord.
Name? What is
Sent to Google one is.
and another one is? No, I don't want.
Well.
Another one is
Another one is my lord.
which court brought?
What?
Which court?
It is my lord.
High court or
No, this court, my lord. Session court.
the next
Fifth judicial magistrate,
next accused with
my lord.
second
Second accused was released. That order is not available with me, but he
what
was
is the
also-
name?
His name is my lord. I'm fine.
Malat, yes, Malat, there may be Malat illegal activities going on, Malat, it's all on Malat. There may be. But they have to inform the forest official. But Malat, in the inform Malat, they are Malat taking money from the, they are searching the Malat the drivers, dumper drivers, whether you have valid authority or not, Malat. And if they have no papers, Malat, they are demanding money. This present Malat dumper driver, Malat, his 164 statement, Malat, is recorded that they are demanding 22,000, Malat 20,000, and subsequently, then when he is not paid money, 22,000 was snatched from him. Again, another vehicle, Malat, when their vehicle is seized by the police, another dumper driver, he came to the Malat police station. He and the handyman, Malat, give their statement that on the earlier day, Malat, they demanded 20,000 and they have no money, sufficient money, 13,000 they have paid. Handyman also said that. Yes. Fact is that, yes, they have doing this for few days. In the meantime, yes, maybe with the Sen Mafia, there are other persons are there because their affair, though already it is transmitted, their affair is at page 30 in the petitioners. I have already seen, one Pappu, their colleague, who is driving their vehicle. There are 4 persons in their vehicle, they, left that person, driver, they all played away, and there's Mafia, then Sen Mafia, attacked those Pappu, and he is injured, he's, yes, Pappu Dekar Mool Fatah, yes, So they are also not doing the legal thing. They are demanding taking the
They may be
yes. But this incident, my lord, attacking them, this incident was subsequent. Earlier they demanded money and took money. And when the truck was released, they are coming in the middle of the road. Another Mafia came and seeing the mafia, they all three fled away. Petitioner and other two. Only Papu was caught, who was the driver of the Malat vehicle. And he was attacked by the all these.
They are
So
the mafia.
yes, they are mafia.
They are the
And
mafias, but
they are doing, they are malat, taking the law in their hand. Malat, why they are
No.
demanding money and all these malat?
No, my lord.
164 statement also there, malat. 164 and other driver also
Now
there.
whether
That's totally, yes. One of them, malat, victim of the circumstance, malat, injured. Now their custody, malat, appeal, but they may not do such activity in future, malat. Taking the law in their hand and
I deny this,
they,
my lord. I deny this.
heard that it's that heard has been tried by the preventing that Goga one it's that or 5, 10, but government had thought by what had got the Goga that that you have have but and 5 5 of ignore of that 5 at the 10 5 after at what that one and other at that at at it by not but but
Yeah.
now but and 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 of 6 and thought by that he can escape it and escape it right of against drug topic of one of coexistence of by drug by when
Alors, এই গল্পের তো পল্লব শইকীয়া, ভারত শইকীয়া, and Sen-
word of him at the book here about love but better so the fire lost by lost by so that of any or topic regarding excavation of private and private property have just extorting money from truck
Truck driver.
from truck driver. You're opposing
My lord.
they have for
not that
my customer.
they done it addition of therefore both grant of it. I have object of both people and get that program here that three of the name in the FIR now have already been translated by the court of jurisdiction. So FIR part of the of it to be stated have been who stated was released by today when date of on the fact if it operate in the it cannot be compared by what of the board hereby directed here what that within the period and operate of if it does like comma in connection appropriate period of pay of 30,000 was subject to for the this for the
Problem. Please don't.
35, 30 submitted.
But I'm already on interim. In the meantime, I'm applying for the
third is that is for a what's the name?
yes, but the protection may be granted.
No, no, I am giving you a much better. What is the name?
Yes, I agree.
Third, that is council for also a water. That is then it council for by order dated 10, 11, petitioner, namely Ravi Motor, was allowed to go on. You have appeared before I. Have you appeared?
He is not there.
That that evidence has been allowed to go on in thereafter has cooperated in the but on the other hand, that petition for has submitted that it those necessary was not for it, however, in by investigation officer has laid the charge, bearing charges number
162/23, dated 28/11/20.
in view of the laying of charges, and in view of the fact that the petitioner has cooperated interim paid granted the petitioner by order dated 10, 11, is thereby
Thirty 36 also, my lord, 30 submitted.
Clear up with the right approach.
heard Mr. S. Islam the council for also heard people and the council for the petitioner has submitted that by order date 14/11/2020, the petitioner, namely Jintu Sathya Elias Adikshit Saikya, was allowed to go on interim and prepared by this court. And in pursuant to directions of this court, the petitioner has appeared before the and has cooperated. On the other hand, the additional that though the case that is fought for how it means that it has been taken by investigator very that
340/23, dated 31/10/20.
in view of the fact of laying of that fact that it has complied with direction and has respected the interim and by order have been declared by
Right.
Happy 430. It's the third number. 406 means 435. The allegation is that two vehicles were taken by accused number one on the basis of contact or car leasing agreement. Your Honor, Your Lordship, I am representing on behalf of accused number two. Vehicle number first vehicle were recovered from Hojai police, and another vehicle was also handed over to the informant.
continue, continue to make it. Don't stop because many people are waiting. So continue.
My lord, ultimately allegation in this case, he is accused number 3. My lord, informant is the hire of the vehicle. He, my lord, initially hired vehicles to accused number 1, and thereafter, my lord, while accused number 1 did not return back the vehicle, thereafter again, my lord, he took another vehicle. Both the vehicles were while my lord not returned back. Then, my lord, he asked him to return back the vehicle. Then thereafter, my lord, the accused number 1 was found impressible along with the vehicle. Thereafter, my lord, by locating those GPS tracker, my lord, he recovered one vehicle at near Huzai market area, first vehicle. And thereafter, while second vehicle was not recovered, then again by my through GPS tracker, my lord, he find out the location, and the location is of my lord, that is the resident of the present accused number 2. Then he asked accused number 2 return to hand over the vehicle. Then allegation against the accused is that he demanded an amount of rupees 2,50,000. Now that is the allegation against accused number 2. And now both the vehicle recovered, but investigation is going on. The accused person, the present accused police, at present charged him, my lord, till now. So, my lord, at this stage, my prayer before Lordship, let him appear and first statement maybe how he is involved, because otherwise, because this is a racket, my lord, in the name of my lord, hiring vehicle. There is also, my lord, though direct, my lord, evidence is not yet available, only suspect that, my lord, they involved after hiring the vehicle, they sold it to somewhere. So, my lord, at this stage, because direct my lord, evidence is not yet available against the present, let him appear statement. Thereafter, my lord, although city available, I will again get the updated case diary.
No, but as of now, material.
Materials, my lord, till now he is suspect. Witness statement is also available. There is
your submission.
I don't have any such report. I keep honor report granted the bill report 161. I don't.
No, but the allegation against is that demanded 2 lakh.
Totally I deny. It's protected.
Then
suspicion is that, my lord, this is a racket is going on. After hiring the vehicle, they sold it to somewhere. But
vehicle was protected by.
Will impose petition, but want to keep it pending.
I want to keep it. I will return back the case there, and thereafter I will again, my lord, probably, my lord, till now there is no. Your lordship may also dispose of.
Let us
Contact was between accused number 1 and informant, not by me.
third, Mr.
Yes, sir.
S. Ahmed. Also, speak what application. Right, but maybe tribute, yes, it trauma, who is apprehending in connection, but the number is what that doesn't make and the second port that port that it for this topic with the fact
14.
that on 14 it not the one it put it at not the fair for the officer in charge of Tata Steel number naming accused person state FIR, including specific as accused number intelligence accused number one had taken one vehicle bearing number. Accused number one named in the FIR had taken one vehicle bearing A09295 for a period of 15 days from first or however, it failed to turn back after expiry of sale date. And in the meanwhile, the number one named in state vehicle also took another vehicle bearing A055 for a period of 3 days. With an assurance to the informant that you would return both the within the stipulated date fixed by them, that is of date fixed by the by in between the number one first informed. However, the accused number one failed to turn back later on. He failed to return back thereafter.
Thereafter, both the vehicles, one vehicle recovered from
That is not in the FIR.
Yes.
That
But,
allegation is not.
that allegation is not against the present. Against the present allegation, he demanded an amount of 50,000 for handing over the vehicle. That's the biggest record.
Later on the with the help of GPS, both the vehicles were located and second vehicle was located near the house of the present. When the informant went to take the said vehicle, the present petitioner demanded it could have been out from the informant for handing over. The counsel for the petitioner has submitted the allegation labeled as are false. What is your reaction? The second
So there is no mention how I was there is no mention of
and what is there in case that
Well, case diary
He
now
mentioned-
police say he is a strong suspect because only the allegation of the complainant
apart from that,
suspicion there is still now there is no such right.
uh, done it petitioner of the other hand has produced the case diary of Tata Steel it one and has shared the submission that there are incriminating material against accused number one mentioned in the FIR. However, at this stage, there is complete stop the and this interrogation would be required for fair completion. Tata Steel. considering submission made with the of as well as considering material available in case that the court is to consider opinion if the petitioner if the above petitioner cooperates with the investigation custodial notice or fair submission of participant. What your petitioner named people hereby appear before the investigating within a period of 10 days from the and cooperate if he does not if he does within the stipulated period of the event of the in connection with one it can be out for paid of
Okay, apply.
Here in this case, the petitioner before your lordship, he is a reporter of electronic division of HP News. And taking a piece, my lord, apprehending arrest in connection with the instant present case, my lord. Zuria PS case number 293 of 20. The FIR, my lord, page 12. Allah to kindly peruse the allegation of my lord is against one Jahirul Islam. This is the allegation of my lord fraud in financial transaction. Page 12, my lord, got it. May I read, ma'am? With reference to the subject cited above, I have the honor to report that as per reliable source information, it came to know that one Jahirul Islam son of such of village such and such, who is a habitual offender of financial fraud, by opening a current bank account in the name of any mushroom business group at ICICI Bank, Shivsagar branch, in the month of April up to November 23, several crore of rupees credited and debited in his current account. Your lordship, kindly note the account number. This is the account of that Jahirul Islam. Now, second paragraph. The said Jahirul Islam with his other co-associate committing criminal conspiracy, conduct heavy financial fraud with the people nationwide, and lastly on such and such the said Jahirul Islam and his other co-accused Saddam Hussein, that is the present petition, therefore I may print. Of such and such take shelter at Povitra Lodge, 6 Mile, Guwahati, in the room number such and such, that day at all total such and such 2,33,93,807 rupees and 12 paisa was credited in his state current account number such and such. All this transaction has been made in the account of state Jahirul Islam. So this is the allegation now. And my case is that, my lord. Your lordship, kindly peruse my petition, my lord. Paragraph 5 of my petition. I was there for sting operation. Paragraph 5. May I read? That the petitioner begs to state that he is an electronic media journalist of NB News and has been covering various news items relating to corruption, fraud, and criminal antecedents of various parts of the state. On such and such, upon receipt of some information, the petitioner wants to Guwahati to cover the news relating to financial fraud being committed by accused Jahirul Islam. Accordingly, he was doing sting operation of the entire plot
to unearth the truth of the matter. During this period of his instinct operation, he stayed at Hotel Pavitra Lodge, such and such, and met Said Jahirul Islam, the prime accused of the case, along with the other. As the petitioner was doing sting operation for the sake of his profession as true media person, and at such time he met the prime accused Jahirul Islam. The police, upon suspicion, implicated him with the case. The petitioner categorically denies the allegation projected in the FIR against. So this is my submission, my lord, and this fact, my lord, for the purpose of fair investigation, needs to be communicated to the investigator. So I am praying, my lord, your lordship may grant, my lord, privilege of bail.
My lord, this is another kind of fraud, my lord, by earning money, placing the burden in another, my lord, soldier. This Zahirul, yes, Zahirul in his, he is a proprietor of any mushroom business group. He opened a current account in the Sibsagar ICICI Bank. He meets this Saddam Hussein, and as per the advice of Saddam Hussein, he came along with his, my lord, bank, my lord, ATM card, checkbook, and all this. And they all meet at here, my lord, 26 mile at lodge. And Saddam Hussein assured that person, my lord, that from to your account money will come, and for every lakh you will get 1,000. On a single day, my lord, 2 crore 37 lakh was deposited in the account of Zahirul. And accordingly, my lord, it was distributed to various persons, my lord. At that time, my lord, the branch manager of ICICI Bank called Zahirul. So what is going on? RBI is noticing that several lakhs and rupees, my lord. My lord, police collected the, my lord, bank statement, my lord, of Zahirul, my lord. My lord, from 200, 300 to 2 lakh, 3 lakh, various amount, my lord. Money came and money went to different persons. So all money went at the same time, my lord. They have done all this. So
any amount is deposited to my account.
it is, yes, my lord, that is, my lord, this type of business, my lord. Maybe Saddam is doing, my lord, gambling and all this, my lord, this activity. Now,
No, but
Saddam, as per the,
the current account,
yes, Zahirul's statement, my lord, from the Zahirul statement that he has taken the on, or Zahirul, Saddam, other 2-3 persons are there, my lord. On Tafazul and 3-4 other person which Zahirul don't, my lord, know their name, my lord. They all sit in the, my lord, that lodge and doing this activity. Zahirul was also present.
He was already arrested.
Zahirul was present, but mastermind is Saddam. So, under what basis? My lord, this is a very initial stage of investigation. FIR law registered in 15th of November, and this all this now, my lord, monetary transaction in the bank must done by the, my lord, through internet, my lord. So, police need some time to investigate and to unearth the truth, my lord. 2 crore 37 lakh deposited in a single account, current account, on a single day, where RBI is noticing gambling is going. Yes, my lord. So at this stage, my lord, this 430 is not made up of this type of person, my lord. This has to be unearthed, my lord. Saddam is, my lord, from the at this stage, my lord, bail, my lord, anticipatory bail.
no, I am not
Yes,
saying that I am granting or
my lord. So,
I
my lord,
just want
from the at present only the co-accused statement.
what he has.
He has said that Saddam has taken that all his stake, account, ATM card, and all this, my lord. And his assurance is that every lakh deposit in his account, he will get 1,000. And already only 10,000 was paid to him by Saddam. That is his statement. At this stage, my lord, very initial stage of investigation, my lord, Saddam, Zahirul was arrested on the same day, my lord, at the date of FIR, my lord, on 15/11. And investigation is going on, my lord. Police collected the bank account details.
Whether, my lord, is the question, my lord. And obviously, my lord, Delhi's
Structural
offense is serious in that some things are going on. That
structural
has to be dealt
intervention is
with, my lord,
necessary, my lord.
severely. I am not on that, my
This
lord.
time-
What is-
Yeah, I have already flagged my lord.
Take it for a take it. Right, right. Down. Yeah. Okay. Yep. That thought. I- Yep. Correct. Thought. That. That. I think that. Correct. It- that- Oh, that. After. Up. Up. It. But. Road. Right. Further update. Further update that it current account present as per the company received by Banker Bank of from one Ramdev Station, Gujarat, by Mint Prime Cell and Uttar Pradesh, Ghaziabad. It further state that state Nirmala and his other quick have been just and brought and court of Nairobi and the other quick Saddam Hussein that had met at Surah Lodge on one of that current account has received or
My lord.
received,
My lord.
Breach and
breach, breach, and after breaching of
that information I have not.
account, there is now and thereafter entire state from left and correct. Back up and other are by nation by that
Reporter, TB News.
here and for by letter date and date date by third upon upon one or cover honor that by and media fit support for payment upon date
Huge
further
amount of
subject by quick it up and get that but what the part of back of
It-
card
ATM passbook and
and what
and
why he does who does
and matlab he issued that for every transaction matlab one against 1 lakh transaction he will pay
he was
a
sure that
1,000 rupees.
against every transaction of the vehicle there will be some pay of
1,000.
1,000, but I think at 10,000. So, F- of video operating part of if there are serious steps of it, where if there are no material at all, then I will go through the path of step.
Time of life.
What better part of item number 14? Criminal division petition my lord is that because not that the one track is seized by the police for a long time. Or either the track is higher purchase, the bank liability is the hospital.
Immediately on reopening, my lord, on third or fourth, my lord, we have not received the report.
One attempt can be on attempt tomorrow to
These are like
earlier.
on all for all other leftover votes. Wherever they-
What?
If, okay, if there are, if it is available tomorrow, even tomorrow,
But the interim, 42 interim is not there. CD is also not there, but
if CD is not there, then
interim
it
is also not there.
then for those cases, first week of the,
If interim, then after 3 weeks.
if interim after 3 weeks, if CD is there, nothing, no relief is there, then within next,
Lordship, supply item that five. Goes up.
I will not disclose it after.
Lordship 36, 32 lordship, kindly.
Item
please
number? Yes. What is your name? Item number?
66.
You appeared before the IO. We are making
My lord, case number 373/23, dated 6/12/20.
There, item number 30 lordship. I'm very have a piece of lordship. Kindly her name be detected. Started at it dispose of by
your name here. Then how did
I just
Lordship, item number 46, and I was there an application for bail. It is a criminal appeal, but yet not this application since it's more than 600 days now behind bar. So any date after bail, I got thought.
what?
Yes, yes.
Regarding agenda 49, related to maintenance, that the husband has not provided any maintenance. Immediately after,
That I have
develop.
that we expected.
item number 41. It is there, my lord, and I have no interim matter.
Tomorrow, day after. 41. 41.
Okay.
That's it. No, it is-
আমি এই লোটে
Delivery.
40 44 sorry 41 Oh, 142 কি চারটাই দিলে what